Lord, 2nd of April, your lordship was disposed of this matter. Some respondents' serial number is in the order, but some is not missing. All these respondents' name must be orders. Mr. Gautam Banerjee Alauddin, 27, 28.
No, there is only one respondent, but 37 has been mentioned. Only one respondent has been mentioned. 37.
No, one appeal is one appeal. Total 47 respondents are there. Union of India have prepared this appeal along with 47 respondents is there. But I have appearing, some name is appeared. Mr. Gautam Banerjee Alauddin, Kazi Safiullah. Some name is respondent's name. Serial number is
from the heading.
From the
Place it under Monday. Or Monday now. Next week. We mentioned.
My Lord, with the leave of my Lord Justice Prasad, my Lord, may I permit to mention one matter before Justice Bhattacharya, my Lord? My Lord,
Yes.
irrespective of classification, my Lord, what happened, my Lord? I am, my Lord, mentioning the matter before the other benches, my Lord, that regular benches says go to the other benches where there is an irrespective of classification. My Lord, what happened? I am the preemptor. I am, my Lord, queen in the.
Do you want
My Lord, inclusion.
inclusion?
Inclusion.
I will be sitting singly. When I
Yes, yes. As and when.
be sitting singly, soon, then mention. It will be notified in the cause list, then mention.
May I have your lordship's kind leave to mention a May I have your lordship's kind leave to mention a contempt application for inclusion, lordship. Grateful.
Next month. Next month. Monthly list.
Grateful.
My Lord, may I please permit to mention one matter?
Yes.
My Lord, on 19th of February, one of my appeal, which is regard to my unregistered e-rickshaw flying in the streets and with regards to my patent, has been posted for hearing on 24th of February, my lords, under the appropriate heading. My Lord, in view of extreme urgency, I am mentioning this matter because the patent involved in this matter is going to expire on 2nd May, my lords. And my Lord, your lordship is having a circuit bench also, my Lord, in the meantime. So, my Lord, if the matter is not heard in the meantime, the cause of action will influctuate, my Lords.
Let it
Because
come.
if the patent is expired, my petition will get influctuated.
If we remember correctly, it is that matter where it is not clear whether you are moving in public interest or you are moving in your self-interest.
My Lord, sir.
That was not clear, if we remember correctly.
My Lord,
So we'll see when it is there.
that my
We are not hearing the matter. It is on the list. We are not going to upgrade any matter right now. Before the,
cause of
sorry.
action will influctuate, my Lord. Then, my Lord, kindly accommodate a date, my Lord, before the expiration, because 2nd May patent will expire.
We
My Lord,
can't-
before that, if the matter is not heard,
Till 2nd May will not be available. If there is an urgency, you can mention before the bench which is available. We can't.
my Lord, then my Lord, kindly release the matter so that I can mention before the available.
When we are not here, you are free to mention wherever you want.
My Lord,
Yes.
without the leave of the regular bench, the vacation bench will not be not here, my Lord. Kindly, my Lord.
How is it will not hear when we are not here? Nobody will hear the matter.
My Lord, it's a
It
regular
cannot be.
matter, my Lord. Kindly consider.
Sorry, you mentioned before. You know how to do it. When we are not here, you can do it. Yes.
My Lord, in one, my Lord, may I leave to mention a matter, my Lord, in one matter, my Lord, it was taken up, my Lord, in 2024, my Lord, motion stage, and one order was passed, and it was made returnable in 2024 itself, my Lord. Thereafter, my Lord, change of determination matter didn't appear, my Lord.
Where were you till now? Determination changed so long back, and today you are awaking from your slumber that it has not come. All the matters which were mentioned, we have got it back on list. You have been sleeping over it. What can we do?
It is returnable in 2024 itself.
Why are you are here after
Motion
such a
stage.
long time?
It is motion stage.
Give it. Find out if there was a direction, then get it listed under the heading motion matter.
May I have your lordship kindly to mention one matter which
Yes.
is not in your lordship list. My lord, this is a restoration application, my lord. My lord, this was dismissed.
Give your restoration. Give any day. Any. Call.
List number 1,
My lord, Tapan Mukherjee, he's for the state.
Lord, I am for the recreation.
My lord, Tapan Mukherjee, he's for the state. He is out of station. I am praying not today.
Yes. What is the issue?
Lord, the issue is that, Lord, my Lord, this all service benefit, including the pension, gratuity, provident fund, all were withheld by my employer only on the ground there is a pendency of the criminal case, private criminal case, which has been lost beyond my service career.
All right, not today. Let him be here. Tomorrow he will be here. Yes.
But may I be permitted to submit the translated copy? That was the direction was there.
Give it tomorrow. What is the? Give them also a copy.
Here, I have given advance copy. I have given.
Item number 2.
Lordship, in this matter, I am appearing, here preferred in this particular application. Lordship, another identical matter on the same issue has been fixed by your lordships on the 28th of this month. My lord, the identical issue is there, Millet. So if my lord can kindly be kind enough to post it to 28th, Millet, then my lord, both the matters can be taken up.
What is the issue?
Implementation of the Sixth Pay Commission, Lordship. And the order which was passed by the Central Administrative Tribunal, we have challenged that order.
162.
They have allowed. The tribunal has allowed the claim.
Lordship. Page 163, Lordship, is then.
It's on 28. You have the number of that case.
My lord, we have
WPCT 52.
WPCT 52 of 2025, Lordship. That is.
Mr. Trivedi.
My lord, please.
Number 3.
My lord, I appear for the respondent number 1 and 2, Metro Railway. The last day ballot, the recapitulation of fact ballot, that though I received the offer to join on 5/12/1996, but due to retention of the quarter, I constrained to join in July 1997. For that reason,
August 97.
August 97, yes.
5/8.
5/8.
What is the date?
That is valid 11/8/1997. And on that day, Your Lordship, yesterday, Your Lordship has harped a very pertinent issue that under what circumstances you lost your one increment which you are claimed for. This is the only query raised before
me, my lord, and I'm satisfying only on that point, my lord. Lest, as your lordship will go into the merit, I will come.
No, we asked you that since you have continued with the Eastern Railway on 31/7,
Yes.
you must have earned an increment on 31/7 before the railway.
This particular scenario changed after the inception of the 6th CPC concern, my lord, when the one extra increment paid to the others who were not a departmental candidate.
So it was with retrospectivity.
Yes, my lord.
This benefit has been granted with retrospectivity.
No, my lord. This particular benefit, my lord, after the genesis of the 6th Pay Commission, my lord, I'm coming on that, my lord. Kindly just go through my merit, my lord. Kindly come to page 73. I'm clear on that, what I'm submitting. Here, my lord, since I'm a departmental candidate, this is the last pay slip or the entire service record forwarded to the Metro Railway by the Eastern Railway. This is the order dated 16/9/98. First, second, third, fourth column, my lord, that is pertaining to the period of training according for, accounting for increment. 11/8/1997 to 18/8/1998. Now I'm coming to the date. 11/8/1997 is the date of joining in the Metro Railway. And then after that, let's go to next column, that is 19 date of absorption. This date of absorption is 19/8/1998 when I completed my training. Then what would be the increment position, my lord? From 19/8/1998, I promoted to the post of the motorman in Metro Railway. Then my next increment.
Just allow us to. Till 11/8/97, you have already joined in the Metro.
Yes, correct. 11/8/1997 I joined, but there was a training period.
How does that matter? That training period, you have not been denied increment during the training.
No, but the next column, date of absorption against the regular cadre on completion of the training. That date is 19/8/1998.
Yes.
So this particular date would be substantial for me. Now the 98/1998, I would earn the next increment on 1/8/1999 because in prior to 6th CPC, there was no uniform date. That particular uniformation has taken place by the 6th CPC, that is 30/8/2006. So by virtue of this particular date, I earned one increment in 1/8/1999, then 1/8/2000, so on, What happened in a year 2006? Those persons who joined, those batchmate who joined prior to June 30th, June 2006, they got one extra increment, And since my joining has been considered
2006,
the effect of the 6th CPC, 1/1/2006, the 6th CPC introduced.
You said joined prior to 2000. You had joined long before 2006.
Yes, but the increment part, which was decided in the 6th CPC, that a person, irrespective of date of joining, there would be uniform date, that is 30th/6/2006. Now, if your lordship consider the 30th/6/2006, mine in after that. So therefore, I lost one increment, and the person, the compatriot, the batchmate,
you have already argued this yesterday.
Yes,
it's not something new you're telling us.
No, I'm talking about where the disparities took place.
No, we are asking you that on the date on which the increment was due, as per the CPC.
Yes.
On that day, you were working somewhere. If not in Metro, you were working in railway.
I was in a.
So you must have got your increment in the railway.
I got the increment ballot up to 2006. There is no irregularity.
Then
But after the genesis of the sixth APC, when the two increment given, those who are prior joined before the 38/6/2006, they got one
you have
increment.
joined much before 2006. Why are you saying 2000? You have
Well,
joined in 97.
My lord, but by date of the increment in a
You
metro
are
railway,
saying
that is
two
written, my lord.
things in the same breath. You are saying two things in the same breath. How do you say about those who have joined prior to 2000? You have joined in 97. Where is the disparity? You are not joined before 2006 or after 2000. That's not the issue. You were only saying that there is a delay in joining, which because of this 8 months, I have suffered a loss. We are saying how this 8 months has put you to a loss. Wherever you may have been, you have earned an increment.
My answer to that effect, valid.
You have not come back with the instruction whether you have earned increment in the railway or not.
I have earned increment, valid, but so far as the after the genesis of the sixth CPC.
That is not the issue here. Your issue, that's not the issue here. You are now introducing a new case. That's not here. Just show us where you have made out this case in the OA. That's not your case. That was not your case.
I'll kindly come to para 29 of my writ petition.
No, I'll not go to the writ. You show from the OA.
No, that thing I have already surrendered yesterday, valid. Because
Then
I
if you have
had
not,
a
then
very
where is the
candid
question?
confession on my part that the points in the OA, these are not well
That does
ventilated.
not improve the situation whether you agree or you don't agree.
Valid, this
That does not improve the
my
situation.
submission
If
would
there
be,
is
valid.
something which was due to you on in August 2006, which was not an issue before the tribunal, it is open to you to raise it.
Valid,
Who is stopping you?
this particular issue is granting of the date of next increment, mallet. It is not specifically mentioned the year, but the date of next increment, mallet.
We are not going to look into anything which was not before the tribunal. We have been
In that case,
very
mallet,
firm on this view.
I have
and
no case in that.
Then you
Because yesterday also, mallet, I have given my candid
no,
confession.
you had said that
Yes.
because of this delay, the release of the quarter was not being done, you have suffered.
Yes.
We said you must have earned somewhere. You have earned an increment before the railways.
Yes, mallet, I had.
Then
But in
how can you get an
2006 the
increment
scenario
from both places?
No,
You
no, no.
cannot.
I'm not claiming, mallet. In 2006, the scenario
That
changed.
is not the issue here. For that, we don't want to express any opinion. If you want to have a liberty to raise those issues, you may do it. There's not an issue here.
Yes, mallet.
It is not an issue here.
Mallet, the benefit already granted to
We
only
don't know what is in 2000. There is no pleading to this effect in the OA. There is no consideration by the tribunal.
I have made my pleading, mallet, in a writ court.
You cannot. You cannot.
Since the lordship is heading the writ court in the court of equity, your lordship may consider those.
Therefore, we can ignore L. Kumar and we can ignore 2010 for SCC 554. All we should ignore.
No, mallet. So the
Please see. We are referring to judgment. Please see.
Yes, that is there, mallet.
Then
That is there.
what can we do?
Point is that
That is the court of first instance. This you cannot raise here.
Mallet,
Whatever is the issue of 2006, you tell us, we'll record. You can go and approach the tribunal. If
yes, mallet. In that case,
Which matter? What is it you are seeking with
Yes.
effect from 2000?
kindly come to page 29, page 12, mallet.
Yes.
Para 29, what I've stated, mallet. Your petition state that due to non-appreciation of the merit of the original application filed before the learned tribunal below, the petitioner suffered the cascading loss in a manner that due to non-releasing from the Eastern Railway, the petitioner belatedly joined in the Metro Railway on 11/8/1997. And if the petitioner could have been released by the Eastern Railway by
You are now raising the issue in para 30. This issue is not there. The vivid difference of pay apparently took place on 1/1/2006.
Yes.
So after implementation of the 6th pay, the fresh equity batchmate who joined up to so they got the incremental benefit on and from 1/1/2006.
Yes.
And since the applicant joined on 1, he failed to get one increment on 1/1/2006 in comparison with the batchmates.
Yes, that is my case.
The issue remains the same.
Yes,
You are claiming parity with someone who has not earned an increment in the railway, who has earned that increment in the metro.
because
Whereas you have earned an increment in the railway.
the issue is different.
Therefore,
I, being the departmental candidate, there would be the technical resignation from the parent department, the leave encashment, everything will go.
that hardly matters.
But the
the
person
point is only of an increment.
increment, mallet.
The
So literally,
disparity in increment which you claim or allege,
yes,
you are putting the increment which you have availed by the railways on the blind spot. then you are arguing or you are making out a case.
No, that,
Others have not got that increment, which you have got from the railway.
but they are getting extra pay in comparison to
We
me.
don't know. That we don't know. You are getting an extra pension or whatever you are getting
Because I
from.
have appointed by that's a legitimate right because my date of appointment from
Therefore, you
1988.
cannot have both benefits.
So, well, I'm not asking for the both benefit, my lord.
In effect, you are.
The pension, my lord, is a qualifying service, my lord.
Pension you have got because you on a higher last pay drawn because you have earned an increment on 31/7/2000 on 1997. Otherwise, you would be getting a lesser pension.
Well,
So pension you are getting more than others similarly situated, and salary you are getting less than others similarly
just
situated.
press one.
You say no, pension also I should get more, and salary also I should get same as others. That is the effect of your submission.
My lord,
The others who were relieved prior to you, they are not getting the same pension from the railway as you are getting.
well,
They must be getting lesser than you.
come to 137.
First, tell us,
Yes.
they must be getting a lesser pension than you. They have not earned an increment on 31/7/97 before the railway.
Because that is my qualifying period is more than that.
So you will get a higher pension than them, and you will get a slightly lower salary. You say, no, I will get a higher pension also because I have delayed in joining, and I will get a same salary also because I have delayed in
Answer
joining.
to this effect, my lord,
Very unique.
lordship query, kindly go to, for my satisfaction, my lord, kindly come to page 137.
Yes.
This, my lord, the salary slip of mine, that is of June 2023.
It has to. Who is saying it is not at variance? It has to be. That's why we say you are putting that grant of higher pension on a blind spot. You don't want to see that you are getting a higher pension than others similarly situated. On the one hand, you are gaining, on the other hand, you are losing. You say, no, both hands I must gain, even though I have delayed 8 months in joining.
Yes, my lord, because of
for some reason or the other, whatever is
the
that.
reason, my lord, that is
Yes.
there. But the difference of where the disability took place, my lord, that is only after the year 2006. Therefore,
Whenever
I
it is,
have taken the
whenever it
plea on
is,
that.
whenever it is. That is
I have
hardly
given a
relevant.
very specific paragraph dedicated
So
to
till
that.
to 2006, everything was fine because you were getting everything more than the others. You are getting a higher pension and you are getting the same salary also.
I raised that.
You are at an advantage.
I raised that
moment that was equalized. You have rushed to the court.
I beg to defer your lordship's opinion in that regard.
Yes.
Because I have put my pertinent representation to that effect just after getting the disability took place in the year 2006.
Correct. That's why we are saying till 2006 everything was all right. Because you were getting a higher pension than your brothers, and you were getting the same salary and higher pension, so you were at advantage.
Arose in 2006.
Till then, there was no dispute as to why I was released after 8 months. Because you were gaining a higher pension and the same salary. So it was a win-win situation. In 2006, that date of increment was fixed. Then that surfaced. Then you became a.
Yes, that is.
How can it be?
That is there because this particular.
As long as you have, then you refund the excess pension that you are getting.
If I have earned not due to my service period, if I have earned due to extraneous reason,
you will keep that also, and then you will take this
that
also.
Is my qualifying service from 1988 from the Eastern Railway because that is the pension rule.
If you had come with a clean hand,
yes, Palat,
saying that look, I don't want this pension which I have got on a higher pay than my others. Let me have the same pension and let me have the same salary. That you will never say.
I have said
you will
so.
No.
I'll show you.
Show us from your way.
Already
show us from your way.
Not about the pay.
Nothing in the way.
That is by admitted fact, Palat. I cannot improvise the infirmity which has been inherent.
Then there is no infirmity in the tribunal's order. Then there is no infirmity in the tribunal.
In that case, Palat, then I'll take the second plea of my argument.
Yes.
That if the learned tribunal has gone into the merit of the RB circular for the retention of the department candidate Palat, this particular situation could not be arisen. Because there is a power and they have exercised that power.
What power?
That particular power, the retention of the quarter in one of my colleague, that is RS Tripathi, which I have given in my representation. They are conferring that right to them, but they are not conferring to it without any.
There is no right to retention. You may apply, they may consider.
Yes,
there is no right.
I am talking about the consideration on the part when the interdepartmental candidate.
Everybody's case does not stand on the same footing. You have been allowed, in spite of that, you have delayed. Even after 4 months, you have not joined. For another 2 months
Yes,
or 4 months.
Valid. There was a medical exigency on my part, Valid, and I have stated
We are
it to
not
my
on that.
department.
We are on whether the rule permits any
My
discretion
lord
in
can
this
decide
regard.
that point also, Valid.
Now let us see. Let us see what is the provision.
Yes, Valid.
But be very conscious. If we allow that, then you will be treated as having left the railway services much earlier, and that it will amount to adjustment of the overdrawn pension. You cannot have best of both worlds. Be very clear. It is very clear to us if there is a mitigating circumstance
Yes.
which the authorities ought to have considered and allowed you to retain or allowed you to leave earlier, given an NOC to join earlier,
Yes,
then whatever benefit you have earned by virtue of continuing in the railways after that date, that you will have to forego. There is a date X. You say on this date I ought to have been relieved.
Yes.
That date X you have crossed.
Yes.
By crossing that date X, you have got an increment in the railway and you have got a higher pension from the railway from what others have got.
Yes.
Now that will have to be set off. That you cannot continue. You cannot blow hot and cold at the same time.
If I render my technical resignation to the parent department, so automatically my service period, the qualifying period would be enlarged on that basis, calculated on that basis, Malik.
Please,
because I'm not a fresh candidate.
We are not saying anything on that. We are saying your service before the railway. That service you cannot have in excess of the date X. The moment you say that you ought to have been relieved on date X, then not one day thereafter any benefit will accrue to you from the railways.
In my understanding, my
Yes.
Lordship is opining,
Yes.
the date which was proposed to be joined in the Metro Railway, prior to that date which I have worked in the Eastern Railway,
Yes.
should not be calculated as a qualifying period for my pension. That your Lordship is saying in that.
No, we are not saying that. We are saying you say that on date X, you should have been relieved.
Okay.
NOC should have been issued.
Yes, Malik.
You ought to have been allowed to join on date X.
Yes.
Instead of date X, they have considered it for 4 months.
Yes.
Thereafter, you have sat over it for 4 months. Date X plus 8 months it has taken you to join. This is the fact. Now, date X plus 8 months, you say this 8 months should be ignored because there was a mitigating circumstance, extreme medical urgency. Therefore, let them treat me as having joined on date X itself.
Antedated date.
Antedated.
Yes.
The moment that gets antedated,
Yes.
then whatever you have earned after date X with the railways, that you cannot hold on.
Subsequent employer, that is Metro Railway.
No, railways we are saying, not metro. That you cannot hold on to. You have continued in the railway for X plus 8 months. That 8 months you cannot have from railway and metro both. That you can only have from one place.
So I have to waive that particular 8 months.
Obviously, how can you have from both places?
Yes.
Tell us, is there any provision that you will be treated as having joined here and then?
Your Lordship, yeah, I got now.
This is what we are asking you since yesterday. That if you have continued beyond date X,
Yes.
you have earned an increment before the railways, then how can you get an increment before the metro on the same date? You cannot. That's what we asked you yesterday. You cannot take benefit from both employers for a period of 8 months. That's why we said you have earned 8 months before railways. You have enjoyed it till 2006. In 2006, till 2006, you are obviously getting a higher pension than others who had left railway with you because you continued for 8 more months. You must have earned an increment in this time. Your last pay drawn for pension must be higher from the railways. You were getting the same salary in metro also. Now in 2000,
Higher salary. Right? In a Metro, I appointed in a higher salary.
same as others. Same as others
Yes.
till 2006. In 2006, a different occurred because of that date of joining of 97.
Yes.
Now you say that should be granted to you. So metro will also give you for this 8 months and railways will also give you for that 8 months.
So that for 8 months, nobody has given as of now, Malik.
They have. We asked you to come back with this instruction. Did you earn an increment on 31/7/97 from the railways? We asked you this specific query yesterday. If you have earned an increment from the erstwhile employer, how can you claim the same increment with effect from the same date from the subsequent employer. How can you? This is a query we asked you yesterday to come back with this instruction. Don't take us to any document. Give us a specific stand. Did you earn an increment in between these 8 months which you spent with the erstwhile employer? If you have, how you can claim a increment for the same period from the subsequent employer? You cannot get from both places. You cannot get from both places. Either you are here or you are there.
If there would be
By deeming fiction, you will get from the other, and by actually being there, you will get from one.
the deeming fiction, I'm not asking, I'm not going on that merit, because this particular anomalies took place in a year 2006.
Sir,
So therefore,
whenever
this is
it
the-
took place, the date from which you are claiming the benefit is from 97 itself. By virtue of non-joining or joining on 31/7/97.
Therefore, my lord, I waived that particular right, my lord, because I'm not disputing those 1997. I am only asking for the period from the
All right,
2006
if you
onwards.
don't want to, then we can't help you.
No,
Sorry.
no, my lord.
We have asked you yesterday, we gave you time, still you don't have instructions. Obviously, if you are not saying anything, we will presume against you. We asked you a specific query, have you earned an increment from the erstwhile employer? You are still now, you are not saying anything.
I have earned the increment from the earliest employer, but the point of dissimilarity took place after the genesis of the 6 CPC. I am
So
only
therefore, even though you have earned an increment from the erstwhile employer on 31/7/97,
Yes.
now you should be treated that on that day you were not working for them. Wonderful. Now we should treat that you are not working for them. You are working for Metro, and therefore now your salary should be at par with everyone here. Therefore, if this is therefore we ask you, if this is what you want, then whatever excess you have earned from there, you will have to, you can't hold on to both benefits.
that is there. That is settled law that I cannot hold two benefits.
So we have been asking you since yesterday.
So I thought my lord is asking for the dissimilarity.
We are not clear to you, then we can't help you.
It's my predicament that I couldn't understand your
We asked you a specific query yesterday. Did you earn an increment on 31/7/97 from your erstwhile employer? If you have, how can you earn the same increment from the same date or be treated as being the employment of the subsequent employer on the same date? Can you exist in two places at the same time?
No.
And can you get benefits from two places at the best? No. You cannot.
No, I cannot.
So which is the one you want? You have to elect.
I have to release that particular 8 months which your lordship is saying.
It's very clear and simple. That's what we asked you yesterday. If you have, you ask him again.
Give me 5-minute break, my lord.
No, no, not today. Tomorrow. Come tomorrow.
Milord, Milord, the
As prayed by Leonard Council for the
this is Milord their own request. Milord, they retain the Milord the whatever Milord in railway.
without hearing, you will not pass any order. Don't worry. Only after we hear, you will
And
pass.
both benefits can
Yes,
be taken.
call the next case.
Milord, kindly make it Milord hard so that Milord, unless it is made hard, Milord, that Milord,
Sorry,
Mayor
call the
adjourn-
next case.
Item number 4.
Keep your-
Why?
I'm for the petition, my lord. But you have served the copy of the application to the. Copy of the application.
My management does not have the copy of the improved order passed in tribunal. Copy টা আমাদের-
A copy of the.
Read টা দিয়েছেন কিন্তু copy of the improved order টা আমাদের দেন। That is not annexed in the read petition.
It is original has been given for that is in there.
Hmm?
Original has been given.
আমাদের তো
Already
copy
given.
টা দেবেন। Improved order copy টা তো
Petition, দেখুন, দেখুন. You see the petition.
When he is saying it is not annexed, you want to verify from the records. You don't trust your friend.
No, the petition, in my petition, it is here. but
Therefore, it is
probably-
presumed that he also has it.
No, that may be mistake, my lord. That is, that may be.
You are asking him to show you, and he is saying he has not received.
Yes, my lord, that will be served to me.
Then you will serve after seeing, go look at every page. Unique circumstance. Give him a copy
Yes.
today, not today. Give it back. He will give it tomorrow. You give the service affidavit tomorrow.
Number 5.
My lord, I am for the petitioner, but the service has not completed yet.
Not required. Let us see what is the issue.
We have served the copy to the petitioner, but
Not required, sir. Let us see what is the case. Hmm. Yes. What is wrong with the order?
My lord, they have not completed the 1 year service.
Who says they have completed? Who has said that they have completed? Where is the finding that they have completed?
The tribunal has directed us to comply the order of this.
Where you said they have not completed 240 days.
Yes, my lord.
Where is the finding that they have completed 240 days?
There is nothing.
Then why are you here? They have asked you to examine whether they have completed 240 days in 1 year or for 480 days in 2 years.
Yes.
And you are here challenging the order. Why? How you are prejudiced by this order, we don't know. And you are saying service and what not. For what service?
Service, we have forwarded the writ petition to the.
Not required. We don't want them. We don't want them. You have to make out a case. What is wrong with this order? Necessarily. You are required to comply this within how much time? 8 weeks.
8 weeks.
And what is the date of this order?
The order is on 7/3/2024.
Unnecessarily, you are killing time also. Unless there is something which you are prejudiced, why should you challenge the order? You say they have not completed 240 days. And you say that they were part-time casual workers. They were not full-time casual. The tribunal says your administrative officer, Siliguri Custom, has said that they were full-time casual workers for 1 year prior to coming into force of the scheme. The tribunal says even if your stand is to be accepted that they were part-time casual workers, then for 2 years, if they have worked for 480 days, they will be entitled to the same benefit. Tribunal asks you to examine these two issues and you are challenging the order.
Therefore, I'm praying some time to.
For what?
To direction upon the department to examine the.
Yes. Take it off. Yeah.
Item number 6.
I am for the respondent.
হ্যাঁ রিলাস
আমি তো রেলে রয়েছি তাই তো রেলে
Union of India.
ইউনিয়ন অফ ইন্ডিয়া কি জানি ইউনিয়ন অফ ইন্ডিয়া
পুরো রেসপন্ড
পুরো রেসপন্স ও তো রেলের আবার আছে
ইস্টার্ন রেলওয়ে ইস্টার্ন রেলওয়ে ইয়ে so far there is a direction for reconsideration of the claim. May I submit before your lordship? What is the issue before your lordship is whether the 3 talak, by way of 3 talak, whether divorce can be granted after the Sahabanu's case. What happened in this case? Well, this is the core issue. My lord, why, my lord? The husband was an employee of the Eastern Railway who died in the year 2023. The wife, being the petitioner before your lordship, applied for compensatory payment and other dues. From the affidavit filed by the Eastern Railway manager, it appears that the talaknama was prepared purported on the basis of 3 talak, and for that reason there is no relation between this petitioner and the husband. That was the stand taken. According to them, they are divorced. I am the divorcee. I produced one thing, that 125 proceedings have been given alimony till his death. Be as it may, my lord, I have drawn lordship attention only 2 things.
In the nomination, that is all that has to be seen by the employer.
For the retirement benefits, my lord, my name was not there. So I am not entitled to get any retirement benefits. So for what is for your lordship, I have to claim, I can lodge a claim.
There are 2 things. One is a nomination for retirement benefit and one is a list of family members which
Yes.
is submitted by every employee.
Yes.
So where is that?
A list of family members, your lordship will find. Are you talking?
They are not to go into whether it is a valid divorce
No,
or it
that is the only thing, my lord. Kindly consider when they are.
So where is your claim based on the nomination and the list submitted by the employee?
Yes.
In your OA, where have you said that you are a nominee and that he has given your name in the list of legal heirs?
No, legal heirs names are not mentioned. There is no, if you logically consider in the nomination, in the pension payment order, 2 names are there. One is the son. and the
TPO
daughter.
follows the nomination. What was the disclosure in the nomination by the employee?
Yes.
Every person who is employed, they have to give a declaration of their family and nominee. So if your name is not figuring in either of these 2 declarations,
My name is not there because
how can you claim?
I am the wife. My lord, if you logically consider, I am the legal married wife. And that is why, my lord, can turn to page 81.
Who is the nominee? Who has been?
Yes, one son, that is daughter Hajiba Khatun, page 81, my lord, can turn to page 81.
So under which provision there is a discretion before the authorities to embark on this exercise?
And that is why, my lord, it was categorically stated, page 81, my lord, thereafter the marriage between the Amat Ali Gharami and Aslima Bibi.
Who will go into this?
Authority goes into it.
Why? Why it will go into?
That is why that was a challenge, because that is why, my lord,
Page 81.
Page 81,
They have
the affidavit. There was the adjudicating authority before the filed a rejoinder. In such rejoinder, my lord, Miss Aslima Bibi was separated by late Amat Ali Gharami on 20.
What is page 81?
This is the rejoinder filed by the adjudicating authority. It starts on page 79.
Rejoinder filed by?
The adjudicating authority before whom this claim was made.
Who is the adjudicating authority?
The senior divisional personnel, Eastern Railway.
Now come to page 82. Before his death, the deceased employee executed a nomination wherein he nominated so-and-so, elder son, and so-and-so for gratuity money, provident fund, GIS money, equal shares.
Yes. So
there is no nomination in your favor.
That is what, my lord, precisely what I am submitting for your lordship. Even if, my lord, I am not entitled to get this nomination, they are entitled to hold the pension benefit.
But whether disentitle me for claiming the same, I can claim the same in separate ways, whether they can act as a trustee or not.
Claim what?
As a matter of way, I'm compensate appointment.
Oh.
That is why, my lord, if a lordship can kindly turn to the page 83, my lord, once, my lord.
Yes, entire issue, they have also got it verified from the registrar
Yes.
that
Even
Talaknama.
that is why, my lord, precisely, my lord, what I am submitting after the promulgation of the whether the after Sabanu's
This is R by 2. Where is an extra R by 2?
next, my lord, your lordship, fine. Page 89.
That has
This is
been
vernacular, my lord.
this has been verified.
It is there. This cannot be the so far the factual expression is concerned. From here, I can satisfy your lordship. This is not binding upon me. Under the statute, my lord, even if, my lord, before the act came into force,
Yes.
the signature of the vakil of the
That is not for the railway. Will only go
That-
by this document.
yes, that is why
You can get a relief from a civil court regarding this, then you may approach them. After that, who is stopping you?
if that evil lordship
This can't precede a declaration by a court regarding this.
after Bharat
This
Kali-
benefit cannot precede
Well,
such a finding by a court of competent jurisdiction.
after the act of Bharat Kalika Muslim marriage 2019, which came into force by that, where it has said this 3 talaq divorce cannot be considered as a valid purpose of divorce.
Yes.
And that was also considered whether it has a retrospective effect or a prospective effect.
Yes.
It was held in
So the railway authority will not embark on this exercise. You, on that basis, you may get a declaration that this is invalid.
Yeah.
Who is stopping you? Go and get a declaration.
That is why, my lord, but the authority, while sending my matter back to the same authority, without saying that this,
It is not for them to look into validity of this. They are only required to verify. They have verified from the registrar office. Registrar office says this is as per the records.
yes,
Therefore, they cannot.
Bharat Kalika said, if a document is coming from a before the authority, and the document itself created or made in violation of the law, whether
No, it was not created in violation of the law.
that is
You
precise.
say a law has come into force under which now it is invalid.
No,
Therefore, that invalidity has to be declared.
2019, and even if, my
This
lord,
is of 2016.
then also, my lord, this certificate requires signature. It is a mandatory.
So therefore, these are things you may raise in the appropriate.
but-
This is not the forum where you can adjudicate this.
I could have understood that it is directed that after getting the such declaration, I can approach. But on the contrary, my lord, the authority, tribunal sending the matter again for consideration. The same thing will happen. The adjudicating authority.
Tribunal has remanded it.
Yes.
What? Why it has remanded?
Paragraph 13 internal.
The problem is that it has said you produce documents. You don't want to do that
No.
because you have failed to produce document. They earlier also they asked you to produce.
125 documents I have produced. 128 proceedings, my lord. I am getting maintenance as a wife. Now, my lord, the same authority was directed to consider the same allegation.
What is the date of order passed in 125 proceedings?
Up to 20 till marriage, till death. Up to 2023, I used to get.
Where is that order? Show us. Where is the order? What is the date of the order? Just show us the date of the order.
Market page 57. This is a copy of the judgment which was passed on
2002, sir.
and it I used to get,
Long before your divorce,
Is-
14 years before your divorce.
and I used to get pursuant to this.
You may say anything.
No, man, page 67.
You may say anything. You may say anything. We are looking at the document.
Up to 27th August 2022, I have received.
You may say anything. That's why we are saying we are going by the document before the authority. Therefore, the authority is asking you to produce a document. And obviously, you don't have.
If those are the documents for
What can be-
consideration, but if it is held that this talaknama is valid, then everything goes.
No. If it is held that it is invalid, then everything will go to you.
Precisely that one. If
Today, it is in the records, very much in the register. How it can be overlooked is a government document. It has to be accepted.
the government document, if a logical government document must be in consonance with the statute itself.
So therefore, we are saying it is up to you to take steps.
Then
You don't want to embark on that exercise.
Precisely that is what my prayer before your lordship. That now the authority has been
That you cannot do. That is precisely what you cannot do. This is not the forum. Neither the authority, nor tribunal, nor writ court. All three forums are not the forum for this.
And that is the premises on the basis of which one of this decision, and it was against Lockstall barrel one it was directed.
So if there is no document, there is no document.
According to them, there is no document.
We are asking you again, show us one document after 2016.
Well, that's what they have paid money that I'll produce before your lordship.
No, you produce it there. Who's stopping you?
But
who is stopping you? They have asked you to produce the document. They are going to produce it. Who is stopping you?
But that portion can be considered in the light of the statute.
No. If you want, then you go and comply with this. If you are so sanguine, then go and show it to them.
And then because my lord, it was held after Savanu's case, my lord, Teen Talak was.
Yes.
Your lordship, there is a duration for 2 weeks, 2 months from the date. There is a duration for 2 months to complete this exercise with the tribunal. Now, my lord, the time has elapsed, so
The
it's a
time.
direction for extension of that period, my lord.
How much time was granted?
It was granted, my lord, 2 months time from date.
Since the time granted by the tribunal has lapsed,
Item number 7.
Item 7, my lord, the presentation form shows, my lord, 10th is the date fixed, my lord, when the matter will be taken up.
10th.
10th. I have served, my lord, in the presentation form, I have served notice, my lord, stating the matter will appear on 10th.
10th.
My lord, let that be on 10th, my lord. My client will be also there, my lord, let that be on 10th.
10th of May.
No, 10th of this month, my lord, day after tomorrow. The notice also I have served, my lord, stating that matter to appear on 10th of April.
Let us see what it is. Your OA has been rejected.
Yes, my lord, I will be leaving in a small thread, my lord. It's a case of removal. My lord,
Removal.
my removal service, my lord, although I have attained more or less the age of where I won't get any government service, any further government service. So in all essence, it has become a case of a dismissal. My lord, in all essence, my lord, although it's a order of removal is there. My lord, I will be banking on a small, precise, my lord, premise that, my lord, me along with 9 other persons, my lord, were, my lord, proceeded on the same charge, more or less same charge. My lord, is alleged charges, my lord, there is certain defalcation of money is there, my lord, with regard to postal services are concerned. Now, my lord, out of those, my lord, one has expired during the pendency of the proceeding, my lord, so nothing, no order was passed against him. The other incumbents are concerned, my lord, some of them have retired, my lord, there is a pension cut of 25%. My lord, 3 were removed, including me, and 1, my lord, who was in service, my lord, it was stated, my lord, reduction in pay and, my lord, recovery of the amount. My lord, I will be beseeching on the judgment of the Honorable Court, my lord, your lordship aware of this, my lord, there cannot be discrimination between the incumbents, my lord, on the same charge. My lord,
There cannot be discrimination.
My lord, this is, my lord, I will try to, let that be on 10th of April, my lord. This is my business.
Everybody has their own individual role. Some may be, having no kind of no active involvement. Some may be having active involvement. Some may be at the center of the entire thing.
My lord, in my case, my lord,
Some may have just performed a ministerial act in the process. How they can all be treated?
let that be on 10th, my lord. My client would be here, my lord, because he will be the last hope, my lord, before lordship. Let that be on 10th, my lord. I will be seeking only 1 day adjournment. 10th of April, my lord, let that be there, my lord. He will be also here, my lord, at least.
Number 8. My lord, on behalf of the petitioner, my lord, I'll be seeking a leave to file up a supplementary, my lord. There was something which have been that was inadvertently that was not been placed out. So from there was an
Cost.
My lord,
Deposit some costs.
my lord, within couple of days I'm going to file up.
We are not allowing this, sir. When you file, you must file with all the documents.
Okay, my lord. That is from Delhi they have given.
What is the issue? Let us see. Where is the charge memo? Let us see. How can you do this on advice of CBC? Just because CBC says the disciplinary authority will issue a charge memo after inflicting a punishment on the same set of charges again.
But kindly allow me to have a supplementary for.
Sorry, we are asking you a issue of law. Where is the question of supplementary? Adjournment is not going to help anyone. There is a punishment you have awarded to him, warning, censure, whatever. And therefore, again, you will issue a charge memo for the same charges because some CBC has written a letter to you. How you can do it? Under which provision? We are asking you. Where is the question of supplementary?
Malad, kindly give out an adjournment for 2 days more. I'll come out with a supplementary and come out with.
No supplementary. We will pass an order that no supplementary is to be accepted. We are not asking for supplementary. We are asking you to give a reply to the query of the court. The tribunal's order is relying upon the concept of there cannot be a double jeopardy. Secondly, the disciplinary authority is required to apply independent mind. Applying your independent mind, you have issued a warning to him in 2017. Now suddenly in 2021, some letter comes from CBC, again you issue a charge memo. Then why not after another 2 years, another charge memo? Continue doing this. Where's the question of supplementary and amendment?
There was an instruction in regard to that, Malad. That's the reason
we are rejecting it. We can reject it right now. We are asking you, satisfy us. Where is the provision? Under which
can be kept out day after tomorrow, Malad.
Yes. You are for the respondent. Give your appearance.
Item number 9.
Well, in item number 9, Mr. Senior Counsel Shanojit Ghosh is appearing for the petitioner. She is out of station, my lord. Kindly fix that matter after 18. 18. 1-8.
After 18th? For the applicant?
Yes, ma'am.
You're for the Union of India or applicant?
Yes, ma'am. In petitioner, the Union of India.
Union of India. Who, you are the advocate on record?
No, my lord.
Why you are here then?
I've been instructed over the phone, my lord. He is out of station due to some medical.
You just now you said senior is out. Now you're saying advocate on record is out.
No, lord. Senior is instructed me. Senior counsel over the phone instructed me to take time.
Who is the advocate on record?
That's maybe. He's also not before the.
The advocate record is murdered, Miss Tanushree Ghosh.
Who has informed him on phone, sir? He does not even know. And he's mentioning here.
Well, Senior Counsel Shanojit Ghosh instructed me to take time, and advocate on record Tanushree Ghosh, she is also not present before the court, madam.
She has not asked you to take time.
No, madam. Senior Counsel has asked me to take time.
Who is the advocate on record? Why she is not here? Ask her to come.
Governor directed to release the 2 months salary, my lord. When the respondent was under the medical treatment and she was referred before the medical board for her illness, my lord. And now they have filed a.
Ask the advocate on record to be here tomorrow, not today.
Only in that case, can he be reacted tomorrow, madam? Subject to lordships.
Let her come, we'll see.
Reacted tomorrow.
Let her come tomorrow, we'll see.
Okay. Get
Item number 10.
Item number 10, 11, 12, 13, my lord, are identical matters. My lord, we are, my lord,
10 to 13.
10 to 13 identical matters, my lord, we are aggrieved by the part of the tribunal's order, by which, my lord, the tribunal has initially, my lord, some part they have allowed that recovery after 5 years is not permissible under the law, in following Rafiq Mashi's judgment and, my lord, Jagdish Prasad judgments are there. But tribunal allowed that after 5 years, that, my lord, the recovery after 5 years is permissible. Now, my lord, in this case, my lord, the petitioner before lordship was a doctor, my lord, serving in, my lord, ESI, Employee State Insurance, Kolkata. Now, my lord, during
So recovery for 3 years only.
the tribunal said, my lord, as because the entire period was, my lord, from 9/6/2016 to, my lord, 1/10/2024, the entire period, well, the tribunal said for the first 5 years, recovery is not to be done.
Also, for the next 3 years, that is what we are saying.
My contention is this, my lord, if I go by the Rafiq Mashi's judgment and, my lord, paragraph 18, clause 3, judgment, my lord, that stipulates, my lord,
Mitigating circumstances in Rafiq Mashi,
yes, my lord.
one of the basic thing is that grade 3 employee.
My lord,
The other thing is when he is retiring,
yes, my lord.
should not be onerous. That was the whole consideration. And if it has continued for a long period of time.
In this case, my lord,
at least group D3 does not apply to you.
1, 2 doesn't
It is
apply.
not a case of retirement also.
No, my lord, 2 doesn't apply. Clause
You are
3
still in
applies.
service.
Yes, my lord. Clause 3 applies.
Yes.
Now, my lord, clause 3 says, my lord, if a amount is paid excess of 5 years, my lord, then recovery is not permissible. In my case, my
Does
lord,
it? Let us see.
my lord, I'm having the judgment, my lord, your lordship kindly have a look. Lord, your lordship kindly takes up paragraph 8, the basis of which, my lord, the paragraph 18 has been brought in.
Last paragraph is the relevant paragraph. The 5 are paragraph 18.
18
Yes.
is the, my lord, the law laid down.
Yes.
Now, my lord, paragraph 8 is the basis of which the law has been laid down.
Actually, whatever it may be enumerated, the underlying thing is whether it is onerous or not. That has been stated in 5.
Yes, my lord. 5 is not in any case.
5 says in any other case where the court arrives that recovery, if made, would be iniquitous or harsh or arbitrary to such an extent as would far outweigh the equitable balance of the employer's right to recover. Now that is what is to be seen, and this is whatever has been said here is for group 3, 4 employees. That does not apply to you.
My lord, your lordship kindly takes up 3, my lord, III. Recovery from the employees when the excess payment has been made for a period excess of 5 years before the order of recovery is issued.
The grant of the benefit was with the rider that will be subject to subsequent.
No, my lord.
Where is that grant of benefit?
My lord, initially.
Pay revision in 2016 order. Just take it out. Where is the order?
Now, my lord, it all started with my initial appointment, my lord, on 9th of June. Now, if your lordship takes up my appointment letter, my lord, that is apparent at page 32.
What is the date of appointment?
My lord, that appointment offer of appointment was 7th of June 2016, and I joined on 9th of June 2016. So, my lord, whatever, my lord, I may say fixation issue is concerned, my lord, we are not challenging the fixation. We have not challenged even. Well, whatever is there, it was from the initial stage of my appointment as a doctor in.
We know that you are not challenging. We have gone through the order, but we are asking you, whatever benefit was granted, which has been rectified according to them, which you are not challenging, did it come with a rider that this is subject to verification and appropriate orders will be passed in future?
No, my lord,
Is there any such stipulation in this order? That is what we are asking.
No, my lord, there is no such stipulation. Your lordship takes up page 32.
7/6/2016.
Yes, my lord. This is the appointment letter issued to me. And in terms of this, my lord, your lordship takes up page 37 is the date of joining, which has been reflected by the authorities. That is on, my lord, 9th of June 2016. And, my lord, the purported recovery, which is said to be now.
Where is the fixation of salary?
My lord, page 38. Page 38 is a common order. My lord,
38.
38. My lord, this is an order dated 27th of September 2023, and my name is appearing at page 40. If your lordship takes up page 40, see, but it's pursuant to the review of fixation and correction of admissibility pay, initial pay in accordance with para 5.
You are taking us to 23. We are asking you, where is the fixation of 2016, which is sought to be rectified? Page 37.
Page 37 is my joining, my lord.
That is where the pay has been stated. 6,600 as grade pay.
As grade pay, my lord. But pay band 3 plus 6,600 as grade pay.
Subsequently, they have found that you are not entitled to this.
This is what they have said, my lord, in 2023 itself. And, my lord, if your lordship takes up, my lord, my name at page 23 is the order, the fixation order, and my name is appearing at page 40 at serial number 12. Dr. Niharika Ranjan Pal, date of appointment is Lal, date of appointment is 9/6/2016. My lord, now the fixation part is there, my lord. It all started from 9/6/2016. I was being given 74,000. It should have been 67,700. And, my lord, it goes down and spiraling down till 1/1/2023, where I was receiving 91,900. It should have been 83,300. Lordship has got it, my lord. My lord,
21 to 23 is the period.
Yes, my lord.
Which remains after the tribunal's order.
Yes, my lord. Now, my lord, my humble submission subject to lordship kind consideration is this, my lord. If your lordship takes up the Rafiq Mashi judgment once more, and, my lord, if your lordship takes up paragraph 13.
Yes.
Paragraph 13, my lord, your lordship may skip, my lord, come to next page 342, Placidum A.
Paragraph?
Paragraph 13, my lord, it starts from paragraph 13, where Syed Abdul Qadir was quoted by the Honorable Court. And, my lord, the first and foremost is pertinent to note that this court, in its judgment in Syed Abdul Qadir case, recognized the issue of recovery revolved in action being inequitous. Dealing with the subject of action being inequitous, it is sought to be concluded that when an excess unauthorized payment is detected within a short period of time, it would be open to the employer to recover the same. Conversely, if the payment had been made for a long duration of time, it would be inequitous to make any recovery. Inference because an action of inequitous must really be perceived as an interference because an action is arbitrary. All arbitrary actions are truly actions in violation of Article 14 of the Constitution of India. The logic of the action in the instant situation is inequitous or arbitrary or violative of Article 14 of the Constitution of India because it would be most impossible for an employee to bear the financial burden of a refund of a payment received wrongfully for long span of time, my lord, thereafter I'm on, my lord, it is apparent that the government employee is primarily dependent on his wages. And if a deduction is to be made from his wages, her wages, it should be the deduction which would make it difficult for employee to provide the needs of his family. Besides food, clothing, shelter, an employee has to cater not only the education needs of those of dependents upon him, but also the medical requirements and variety of sundry expenses. Based on the above consideration, we are of the view that if a mistake is making a wrongful payment is detected within 5 years, it would be open to the employer to recover the same. However, if the payment is made for a period in excess of 5 years, even though it would be open to the employer to correct the mistake, it would be extremely incautious and arbitrary to seek refund of the payment mistakenly made to the employee. Now, my lord, I am on this, my lord, and if your lordship goes by paragraph 18.3, my lord, subject lordship kind consideration, my lord, paragraph 18.1 makes it clear, group D, group C employee, it cannot be done. With regard to paragraph 18.2, my lord, who has retired or going to retire in 1 year, it cannot be done. And now paragraph 18.3, my lord, it's derived from paragraph 13, and my lord, it says recovery from the employees when the excess payment has been made for a period in excess of 5 years before the order of recovery issued. In my case, my lord, the order of recovery issued No, my lord, I have enjoyed this thing for more than 7 years. And if I subject lordship kind consideration, my lord, my humble submission is this: the Honorable Supreme Court has categorically mentioned, well, had that been only confined to Group C, Group D, my lord, then third clause, fourth clause, or the fifth clause, my lord, which is applicable to regardless of any of the facts and figures, any of the employees, my lord, that would have become meaningless. My lord, this, my lord, 18 clause 3, and my lordship also takes up clause 4. If I am being subject to higher post, my lord, I will be getting that salary. My lord, these are not related to Group C or Group D employees. My lord, subject lordship kind consideration, my lord, my understanding, I may be wrong. My lord, my understanding says, my lord, if I've enjoyed this for more than 5 years, in this case, my lord, I've enjoyed for more than 7 years. My lord, at this stage, my lord, recovery of all the money which I've received till 7 years is...
That's not the case. The tribunal has tried to strike a balance, saying that only 3 years will be recovered.
Even if the tribunal's order, if a lordship go by the tribunal's order, the tribunal has said for the first 5 years, recovery. No recovery, and thereafter
only 3 years.
Now, my lord, only thing is, even in the tribunal's order, there is a defect, I may say, I will come to that, my lord, that is a secondary part. But what I'm beseeching before lordship, my lord, is this: paragraph 13, my lord, makes it absolutely clear, my lord, in Rafiq Mashi, my lord, taking a cue from Sayyid Abdul Qadir.
And this Rafiq Mashi has been subsequently considered by the apex court. You must have seen that judgment.
Thomas Daniel, my lord, Jagdish Prasad, and my lord, in April 2024, it's also with regard to stenographer of district judges, my lord.
2 days ago.
4th of April 2025, my lord, 3 days back.
Correct.
My lord, this Jagesh Shah was a district.
Where is that? That I was telling my brother.
I do have the copy, my lord.
Let us see.
But in that case, my lord, with regard to this is stenographers. And my lord, this is reported in 2025 SCC Online SC 724. My lord, in this case also Rafiq Mashi was considered, but in this case, my lord,
in this case the fact was
different, a bit different, my lord. I may say, my lord,
very much different.
Yes, my lord. This is a case of
there was a conscious grant.
Yes, my lord.
Subsequent decision not to give.
Yes, by the High Court.
By the High Court. This was not a case of mistake.
Absolutely, my lord.
This was a conscious grant. Subsequent decision that no, we will not give this.
That's true, my lord.
And they were stenographers. They were retired.
They have retired in 2020 and 23 was the order which the.
So in their case, it has been found iniquitous.
But my lord, Rafiq Mashi, as of subject lordship, kindly.
No, Rafiq Mashi has been considered in another case.
And another case, my lord, in Thomas Daniel, and thereafter, my lord, Jagdish Jagdish Prasad Singh, my lord, in those two cases also Rafiq Mashi has been dealt with.
No, there was a judgment wherein the apex court has considered that recovery can be made. That judgment is considering Rafiq Mashi. Because see, the tribunal here has tried to strike a balance. It is not so iniquitous for you. 5 years it has said don't recover. Now whether no recovery should be made whatsoever.
My lord, paragraph 13, I may say, my lord, subject to kindly, my lord, paragraph 13 is the paragraph
That
is.
we have said that we will consider, don't worry. What you have argued, we will consider. Judgment is somehow it is, I am not remembering the judgment.
Paragraph 8.
And why this excess payment has occurred? What is the reason?
My lord, my initial appointment, my lord, they have made a mistake, my lord. I may say, my lord, subject to kindly. My lord, that is absolutely in their domain, my lord. In the affidavit that they filed, or the reply that they filed before the tribunal, they have categorically mentioned, my lord, that it's not the fault of ours. My lord, that has been mentioned in the reply they filed before the tribunal. If your lordship takes up the tribunal's reply, my lord, where they have stated, my lord, if your lordship takes up, my lord, page 63, my lord, this is the reply starts from, my lord, page 59, my lord, page 63, my lord, in the other paragraphs also is there. My lord, page 63, paragraph 9, I may say, my lord. This is the reply they have filed before the learned tribunal. Has got it, my lord. My lord, with regard to the statement made in paragraph 4(9) of the said application, the statement that she has no role at all in pay fixation, and neither there is any representation, fraud, or any other unlawful steps taken by her for her pay fixation is completely correct and matter of records. But the contention she cannot be made subject to any recovery for excess amount paid to her by the respondent authority is denied and disputed, as the pay fixation was made erroneously. The amount ought to be recovered as the amount was paid excess to her. She had no right to enjoy the public money paid in excess to her. Her contention and appeal for non-recovery excess payment from her pay and allowances may be dismissed by the and the applicant may be ordered to pay the excess amount. So, my lord, it is the, my lord, admitted fact of the contention, my lord. I have no role whatsoever, my lord, in, my lord, either, my lord, fixation of my pay from the initial stage when I joined till the, my lord, the recovery or the, my lord, fixation, purported proper fixation was done in 2023. And, my lord, in the reply also, my lord, in other paragraphs also, my lord, they have, in paragraph 10 also, my lord, your lordship will find the same thing they have stated. With regard to paragraph statement made in paragraph number 10x of the said, my lord, 6 lines from the top, your lordship may read, my lord, however, due to error in fixation, the applicant has been wrongfully paid excess money for the period of 9/6/2016 to 39/2023, as the same has been found out at a later stage.
What is the amount being recovered per month?
My lord, my lord, initially, my lord, London Tribunal grant me stay with the recovery part. My lord, thereafter, my lord, the matter went, they filed reply rejoinder after filing of exchange of affidavits, my lord. Ultimately, the London Tribunal passed the order. Now, my lord, a recent, my lord, yesterday, my lord, through email, my lord, I've been told, my lord, email we have received, my lord, wherein it says, my lord, an amount of, after this calculation is 4,63,563 is said to be, my lord, after this calculation, what they have done, my lord, is.
So around 6.5 has been.
Yes, my lord, this is.
No, but that will be that will be done monthly, or it will be a one-time return?
Money, it will be taken out monthly, my lord, I've been told. Well, I'm just reading out, my lord, I'm just giving me time, my lord. Well, you can have a look.
No, you tell us.
No, my lord, I'm
It's
just
not part of the record. Why should we take it?
This 21 lakh. Use excess. Well, it doesn't speak of any such thing, my lord. It doesn't speak whether it will be taken out monthly or on one go. No, recovery 18 cash. No, it is a file number. My lord, this order doesn't speak, my lord, the mode of recovery is.
We understood. We understood. And why only 5 years it has? How the decision has been understood? Rafiq Masih decision.
It says if it is excess below 5 years, my lord, recovery is permissible. If I am not going to retire within 1 year, let's say I have got service of 5 years left, and my lord, if it is a recovery is done within 4 and 11 months, 4 years and 11 months, recovery is permissible.
Where do we get this from the judgment? That is what we are asking.
Paragraph 13. Your lordship kindly takes up paragraph 13 once more, my lord, of the Rafiq Masih judgment, my lord, where Sayyid Abdul Qadir was taken into consideration.
We are asking you where the tribunal has come to a finding that 5 years it will not be recovered. After that, it will be recovered. What is the basis of this?
My lord,
how Rafiq Masih will lay the foundation of arriving at such a conclusion that for remaining 3 years you can recover? Please try to understand our query. The tribunal has relied upon Rafiq Masih. So from where in Rafiq Masih, from where it has culled out this proposition that after 5 years recovery can be made?
My lord, it's nowhere in the order, my lord. I couldn't find, my lord. My lord, it only says, no. It only says, my lord, I've quoted Rafiq Masih, my lord. Thereafter, their lordships, my lord, of the London Tribunal, my lord. My lord, they have lordships have taken view of, my lord.
3 says recovery from employees when the excess payment has been made for a period in excess of 5 years before the order of recovery is made. So if the excess payment has been made for in excess of 5 years, no recovery is to be made.
That is my contention, my lord.
It does not say that up to 5 years you can recover, and after
contention, my contention
you have not submitted till now.
I'm extremely sorry, my lord. My lord. That is what my contention is. If I've enjoyed that thing more than 5 years and above, then no recovery is permissible.
That is why the part of it.
That the payment has been made. That will not apply to chicken. So, it's not, all of these conditions are not to exist cumulatively. Following few situations. What will be given? Few situations wherein recovery is permissible. One of the situation is 3. So when it has found stomach of a lot, the finding accepted the yes.
But, I am submitting before your lordship. This is Rafiq Mas is applicable only group C and group 3 and group 4 employees. Though in paragraph 18, it has been stipulated that recovery from the group 3 employees, group C and group D.
First you have not challenged the order of the tribunal.
Yes.
You have not.
Only 5 years has been
you have not challenged the order of the tribunal. Therefore, you cannot argue this. The tribunal has found it is covered by 5 years, and that is not accepted by you. So once the finding of 5 years is there, then how any recovery can be made? If this judgment applies, then recovery cannot be made. If this does not apply, then only recovery can be made. You have specifically stated that they have no role to play in this. And why it took you 8 years to realize how it was discovered? What have you said in the reply?
Refixation at the time of refixation, it was discovered.
Refixation for some benefit of revision?
Yes, my lord. Page 23, if you lordships kindly, not page 23. 2023, recovery, refixation made, my lord. If you lordships kindly have a look.
Page 23 of?
Page 23, my lord. Kothay available? Later. Memota. Page 30. Page 38. Page 38. Fixation was made on 27th of
Pursuant to review of fixation and correction of admissible pay. So when this review of fixation has been done, why did you not review it earlier? Based on internal audit.
Only have stated on the basis of scrutiny and correctness of fixation of internal audit regional.
It says pursuant to review of fixation. The has to review the fixation. Would have reviewed it immediately. In all the cases, the fact is the same.
From the same, my lord, only 2 orders, my lord, in first 2 matters. My lord, the recovery was done in 27/9 order, and other matter, my lord, order date is different. 7 except issues are same, my lord.
They all joined on the same date.
Yes, no, my lord, in different dates. But in
that same transaction, maybe on different dates.
Yes, my lord. And my lord, the amount is also, my lord, different, my lord, subject to whatever is there with the court doctors.
But in all cases, the tribunal has said 5 years.
Yes, same final, same order of the tribunal, my lord. All were heard in one day and order was passed.
So just one judgment we want to consider, you have not got it. And unfortunately, I am also unable to remember. This Rafiq Masih judgment has been considered subsequently, wherein it has said the circumstances where recovery can be made. Just have a look at that. It should be couple of years after this. Maybe 18, 17, 18, something like that.
Well, the tribunal has considered one matter, my lord, in the tribunal's order. It is there. I have gone through that judgment. My lord, in that case, the tribunal said Rafiq Masih is not applicable because of the reason it's 3 years is there. My lord, in that case, my lord, the recovery was done within a period of 3 years, although they have retired. Thereafter, your lordship kindly takes up the judgment, my lord, of my lord. My lord, this is a judgment, my lord, which the tribunal has dealt with. The 2022 SCC, my lord, tribunal has dealt with MP Medical Officers Association. This is the judgment. Report in 2022 SCC online SC 1099. My lord, but in this case, as what has happened, my lord, the recovery period is of 3 years. 2019.
No, then that is in compliance with Rafiq Masih.
Well, if that says, my lord, it
That
says,
is not in any way at variance.
I
That
don't
is,
have any religion, but the tribunal has dealt with this matter.
there is one judgment, I can't remember right now, but we should consider that also. For further submission.
2 days, I will next week. I will not in Calcutta.
No, after that it will not be possible. This bench will not be available. Let it come, then it will come much later. On 5th of May.
Well, only thing, my lord, your lordship kindly leave, my lord, as because, my lord, the subsequent order has been issued by the authorities, my lord, no recovery can be made unless your lordship is hearing out the matter.
Yes. Don't make any recovery till the matter is concluded. Don't, yes.
But they are the union, my lord, ESI authority.
ESI is not here.
Well, we have served, my lord, this is the affidavit of service, they have received it.
Then let it come on 11th, list on 11th, 2 p.m.
PM, my lord.
Yes, 2 p.m.
It's declared. But should I file the affidavit?
Just find out who appears for ESIC.
SC Prasad, my lord, I have been told.
If you can reach out to him and see if he wants to appear.
But should I file the affidavit of service?
All 4 matters.
Should I file the affidavit of service, my lord?
Affidavit of service taken on record. Take the affidavit of service taken on record.
You will also kindly record an order. You will also kindly record an order that it will be appear on the 11th.
Yes. Yes, call the next.
Number 14.
Yes.
My lord, I am appearing on behalf of my senior Mr. Raja Ghosh, who represents the petitioner. Due to some medical issues, he is not available today, my lord. My lord, kindly let this matter appear after 11th of April.
Yes, why after 11th?
My lord, due to some medical issues.
Why have you challenged the order? The tribunal has directed to refund the recovery, still you have challenged the order? As paid list after 1 week. He's giving covered.
Number 15.
Covered. Refund. Saying when they are refunding, why?
My lord, in item number 15, my lord, I am appearing for the Union of India, my lord. My lord, I have not received a brief, my lord, just appointment letter I have received.
Yes.
With regard to the service, my lord, I would like to point out one thing.
No,
Respondent
we'll
number
come to
3 has-
service later. First, come to the merits. If required, we will direct you to serve. If not required, we may proceed.
My lord, the petitioner had been recommended for the post of telecom maintainer grade 3, my lord, by the RRB Kolkata in 2006. My lord, the railways thereafter submit that
Telecom maintainer
grade 3 in 2006, my lord. And I was
Yes.
informed by the RRB letter dated 4th of April 2006. Now, my lord, initially the railways did not confirm my appointment and did not give me the appointment, my lord, because as per their submission in the tribunal, that they did not have any vacancy. That is the first contention of the railways.
Yes.
Thereafter, my lord, they offered me they sought a consent from me, that is the Eastern Railways, sought a consent that whether I am willing to join Southeastern Railway.
You have not annexed your OA.
My lord, the OA I have not in.
Why?
My lord, the entire annexures of the OA are annexed.
Why, sir?
The OA
Your
itself-
pleadings in the tribunal is to prevail over the entire proceedings. What you say in the writ petition hardly matters.
My lord, kindly allows me a supplementary affidavit. then.
Supplementary. Very good. Pay some cost. We are very firm on this. Why should you not annex the OA? Why should you make out a fresh petition in the writ petition? Are we to look into these pleadings or we are to go by the pleadings before the tribunal? The law is very well settled.
I acknowledge, my lord.
Where is it? You have a copy of the OA? Give us.
My lord, right now I'm not having. If my lord
Hey, sir,
passes over the
how
matter,
many-
I will just bring it, my lord. If my lord is pleased to just pass over the matter.
4/4/2006. You say the recommendation was made.
Yes, my lord, and that is annexure P1, my lord. At my lord, page 17.
Yes.
Now, thereafter, my lord, in 2008, my lord, 24th March 2008, annexure P2, the very next page, my lord, a consent was sought from me from the Eastern Railways that whether I am willing to get absorbed in Southeastern Railways. This was sought from my end. To this, my lord, I gave my consent. Thereafter, my lord, after a lapse of 2 years from 2008, that is on 8th of March 2010, the Eastern Railways wrote back to Southeastern Railways seeking their consent whether they are willing to accommodate. To that letter, my lord, Southeastern Railway immediately replies on 16th of March 2010 in a matter of 7-8 days, my lord, that they are willing to absorb 24 of the impaneled candidates and sought the papers from Eastern Railway. Now, at this point, my lord, Eastern Railway goes quiet, and therefore, this entire appointment process gets stalled. Now, I have annexed the reply of the railways in the tribunal, and I would seek to refer to, my lord, page 35 of my petition. This is the RRB letter to, my lord, Eastern Railways after the panel has been made. And this letter, my lord, one thing that I would like to point out here, my lord, is that the Eastern Railway itself sent an indent or a request for 43 candidates, my lord. And the RRB finally recommended 42 candidates. So now the contention of the Eastern Railway before the tribunal that they did not have the vacancies, that is fallacious, my lord.
Your name in the panel vests any right?
My lord, panel is at page 36.
Will that create any right in your favor?
My name is in third place. Panel is in page 36, my lord. And this is part of the railways pleadings in the tribunal, my lord. I am at number 3, and those who are appointed are in number 7, 8, 9, and 10. My lord, to summarize, my lord, absolutely for the latches of the railways, I am today not employed. And I am having to work as delivery boys or something.
You are SC or ST candidate?
I'm an SC, my lord. And the letter at page 35 would reveal, my lord, 6 SC candidate was sought for. I will add to it, my lord, that this is an unfortunate litigant, my lord. Before the administrative tribunal in Calcutta, my lord, for the first time, matter was heard and orders were reserved in September 2021.
You have approached the tribunal in 2014.
My lord, before that, I had approached the tribunal in Patna, my lord. The order is at, my lord, page 25.
55.
25. From there, my lord, it was withdrawn with a liberty to file before the Calcutta bench. In 2012, I have filed, my lord, in Patna. Sorry, my lord, Ranchi.
Still, 5 years after you have approached the Ranchi tribunal.
Some precious time was lost for this RTI. and all that.
5 years is some time.
Well, time has
5
been.
years is quite a long time.
I had made some representations and also tried to obtain certain documents, my lord.
Make some more representations. Who is stopping you? Yes. From there, the issue of limitation was raised, you withdrew, and then you came to this tribunal. And in this tribunal, the issue of limitation has not been considered.
My lord, liberty was also given, my lord, by the tribunal in Ranchi, my lord. Liberty.
Obviously, otherwise your OA would have been thrown out. That much we know. But the issue was very much raised by them, jurisdiction as well as limitation, both. That you are approaching the tribunal after 5 years, and that also a tribunal which does not have jurisdiction. How can a tribunal or court pass an order in these circumstances? Can't be. And your OA is also not here. We don't know what you have done. What RTI, what application, what representation, nothing is here. Have you dealt with the issue of delay in your OA?
Hello?
In your OA, have you dealt with the issue of delay? 25.
My lord, kindly then allows me some time, my lord. I will come back with the OA, my lord, and also a supplementary affidavit, because that has to be filed.
Come with a copy of the OA, no supplementary affidavit. Let the learned counsel for the petitioner produce.
This is beyond record.
Affidavit of service kept on record.
Item number 16.
In this matter, I am appearing for the petition. Union of India. Finally, the impugned order. The cause of action arose in Ranchi, at Ranchi, my lord. Judgment passed by the Honorable Tribunal. Last annexed regarding the withdrawal of the voluntary retirement from the service. That is the that's sorry. Gather.
Yes.
Now, kindly see, here is first notice was made by the petitioner respondent here in page 5 in the judgment on 29th
No, where is the
November
notice?
2021.
Where is the notice?
That
Show
is
us the notice.
Yes, notice.
My lordship, I am the respondent of the.
Yes.
I am the respondent, my lordship.
Yes.
Order is in page 36.
Wait, when your turn
Now,
comes.
kindly
then-
see, it starts from page 34 and step 1. Page 34. Prayer for voluntary retirement from government service and thereby giving 3 months notice for the same under Rule 48A of the CCS Pension Rules, 1971. Then, my lord, withdrew on 10th February 2022. February. Again, my lord, 14th February 2022, to proceed with the VRS and to treat the letter dated 10th February 2022 as null and void. Respondent himself declared.
And when it has been accepted,
then my lord, on again,
what is the date on which the decision has been taken to accept the VRS?
my lord, page 667. 3 times, my lord, 4 times, my lord, they wrote a letter to VRS and again subsequently they withdraw.
What is the date on which the authority has decided?
Definitely, page 67.
It's not page
charge
60.
report 38, my lord. Yes, my lord. The accounts officer certified that the charge of post accounts officer, page 38.
Page?
So the director of accounts Ranchi is requested by Sri Partho Bhadro on 1st March 2020 consequent upon his voluntary retirement from service by postal dated PA Wing New Delhi order such and such dated and his office order number such and such on to dated 1st March 2022.
And where is the application of 28 to 22?
28 to 32. That's 28. But kindly see page 36. 28 February 2022. Notice for voluntary retirement from government service, case of Sri Partho Bhadro, AO, State Accounts Officer, AO Office, AO Rachi. Member Finance is pleased to accept the notice given by.
We are asking you where is the application of 28 to, you are showing us 23 to
20. Accounts Officer, my lord, this is the member is pleased to accept the notice given by under mentioned assistant accounts.
Where is the application of 28 to? Why don't you show us?
Yes,
Why
yes,
are you
yes,
reading
yes,
unnecessary?
yes, yes.
You read the entire brief.
Yes.
We ask you one for one page.
20.
Wasting time unnecessarily.
8. My lord, the application made on 29th, my lord, and that office has accepted on 28th to 2020 on the basis of 29th 11 2021.
29/11/21.
21. Date of notice for voluntary return.
He has made 3 applications.
3 applications.
First application is of 29/11/21.
29/11/22.
Second is of 14/2/22. Third is of 28/2/22.
Yes. 14th, second. At of 14th, 15th August. Accept.
It is 23rd February.
23rd February, that letter was annexed in this petition, 37 page. 23rd February 2022.
Can you hear us when we are saying 28/2? Why are you repeatedly showing 23/2?
20, not 23, 22.
Can you understand 28/2 and 23/2 are 2 different dates? They are not the same date.
इससे तो नहीं है एखानটাতে রসের যেটা দেখতে চাই এটা 31st August. অ্যাপ্লিকেশনটা নেই সেটাই তো জোসেফ চাইছেন that application was not there. My application on 29th and
You have not
10th
gone
February
through the,
2020.
unfortunately, you have not read the brief.
I have read the brief.
Come to page 71. It is not there. And I have read the brief. What you have read, we have understood.
28th February 2020.
Yes, we have understood what you have read.
That was not serially mannered. This is the
Read the brief.
71. Right.
Don't bother to go through the brief before addressing the court. That is the whole problem. After that, has he given any application? After 28/2, has he given any application?
28 to 22 after. Really, Saja. This page 71, 28 February, 10 February. Yes. It's a review appeal.
That is give a date.
Done.
Signature has to take it.
The last, my lord, and afterwards, my lord, the respondents made a representation to the Honorable Prime Minister, page 40 on 31st August 2022. Page, my lord, 40.
Here. After 1/3, after 28/2, there is no application.
No. After 28, there is no application.
Yes, you made any application for withdrawing after 28/2?
Yes, my lord.
Where is it? Show us which application.
Only letter to the Prime Minister, Honorable Prime Minister, page 40.
My lord, I have written letter to the member finance, Department of Telecommunication on 15th August 2022 and letter to the PMO on 31st August 2022.
That is the only reviewing, not for page 39.
For restoration of my services.
Page 13.
No, that is after the after your VRS was accepted,
Yes, my lord.
not before VRS was accepted.
Not before, but my lord, I withdrew the VRS on 23rd February.
That we have seen. Then again you ask them to proceed. Again you withdrew. Again you ask them to proceed. So last time, therefore, we wanted to see when you have asked them to proceed on 28/2, you say that let it take effect from 1st of March. So on 1st of March, they have passed the order accepting the VRS. Then how it can be overlooked? Why? And you have not said anything for at least 5 months thereafter. Your first communication is of August.
Yes.
When you have written to the member finance.
Member finance department
In August.
In August.
Where is
15th
that?
August.
Which document?
Page 39, man. 15th August.
How you have made an application on a national holiday? 15th
Lord, I returned back home after that.
No, but on national holiday, how you have submitted the application?
It was sent by post.
Where is the rule? Rule 48, let us see.
Yes.
PCS pension.
I have annexed, my lord.
You have annexed it.
My lord, the page 72. Annexed P3. I have annexed all rules, my lord.
Page 48.
Retirement on completion of 20 years qualifying service. That is 48 says. 2, 3, and 4. 4 is the relevant one.
Oh. So twice you have withdrawn the request. After the 2 times when you withdrew the request, did you receive any communication from them?
No, my lord.
Yet. Within the communication. Yes. That we proceed with the action. But there is no specific approval. As a pure condition.
The request for withdrawal is within 10 date of the next 48.
Yes.
Then, my lord, when the cause of action arose in the Ranchi, they dismissed their service and they wrote, but Honorable Tribunal, my lord, the Calcutta bench tried this matter, my lord.
But that issue you have not raised before the tribunal.
Tribunal, my lord. That's true. That's true, my lord. That's
We'll see. We are coming back.
and in paragraph
Pardon.
Sorry. Yes.
My lord, am I audible, my lord?
Yes.
Am I, my lord, actually, with regard to item number 50 and 53, which both are fixed at 2 p.m., I am for the respondents. So, my lord, I am on personal difficulty. I am praying for an accommodation. I am down with cervical spondylosis. So, my lord, I have spoken to Mr. Kollal Basu appearing in item number 53.
Yes.
He suggested on 16th April at 2 p.m.
Advocate's personal inconvenience and illness, my lord, what we have learned something in the bar. So we're at 16 minutes subject to convenience at 2 p.m.
Item number 50 and 53.
Today we have fixed it on 16th at 2 p.m. Some
Well, item number 50 and 53.
We've already fixed some matters on 16, 17, therefore may not be possible. After that,
Lordships will not be available
after 2nd May only.
Very well, very well, very well, my lord.
Yes, my lord. Then, my lord, 5th May possible, my lord.
If you want it fixed at a time, then 5th may not be good.
Then 6th May.
Somewhere after that, 7th, if it is.
7th May.
Yes.
So, my lord, kindly fix it at 2 o'clock. That will be it's a hearing
That is
matter.
what my lord, that is what my lord is saying.
Yes.
7.
So there are two matters. In both matters.
Yes, item 50 and 53.
8th May, my lord, we are 7th May, another matter has been fixed. 8th May, my lord.
Very well.
Deeply obliged.
8th is free. As jointly prayed for further. $50. 50 also, Mr. ASG.
Yes, Mr.
My lord, in 50, Mr. Banerjee has concluded his submission. I am to give reply.
Concluded, my lord. Only one thing I had to submit.
He has not concluded. He says he has not concluded.
He wants to add something.
One thing, my lord, at the outset, I should draw my lord's attention. Some recordings are there which is not factually correct. Paragraph number 1 and 2 of my lord's earlier recording.
Yes, let us see. Where's the file? Lists. Set this list. Yes, what is the
their own request were transferred to another lien wherein they were placed as LTC scale of 975 to 1660. It's not that they were, my lord, at that point of time as TSPA, their scale was 975 to 1660 as per Fourth Pay Commission recommendation as on that date, because after promulgation of Fourth Pay Commission recommendation, they were transferred. Well, it should be that they were, my lord, TSPA in the scale of 975 to 1660. When they were transferred, my lord, as LDC and my lord, allowed as LDC, that scale was, my lord, 950 to 1500.
Oh, LDC, there was a different scale.
Yes, my lord. That's why, my lord.
Anyway, we'll see. This is not a final order.
This was my
not a final order.
My lord's kind attention that this recording is there. And my lord, in paragraph 2 also there.
So therefore now it is for him to, there is no argument to be advanced on your behalf. Don't worry that.
I'm not advancing, only thing, my lord, this your recording is.
All right, we'll see, yes. So it is for you, Mr. Chakravarti, for your submission. When do you want?
Yes, my lord, kindly fix it any date. My lord, I have no objection, subject to the other matter. Lordships had been pleased to fix on 8th, possibly 8th May at 2 o'clock.
So that day we'll fix this matter also.
Same yes, day. At 2 o'clock, that will be, I am appearing for this.
Yes, same order.
Grateful, my lord.
50, 50.
50 and 53.
Yes.
Item number 16.
And this, not one office order. আমি একটা জিনিস দর্শককে বলে দিই, that is the, it is our mistake that has been pointed out. ওটা না বলে দিলে হবে না, তাই না?
8/2/22 is the last application. And 1/3 is the date on which it has been accepted. And in between 28/2 to 1/3, you have not filed any application. The first application you have filed on 15/8. 5 months thereafter. That also to some authority who is not the competent authority. And thereafter you have made an application to someone who has nothing to do with the issue. So how it can be considered that the VRS was withdrawn by you?
My lord, I withdrew my VRS on 23rd of February 2022, and my VRS was given on 28th of February after 5 days.
No. On 28th you applied.
After in the afternoon, my lord, when the order of VRS came to the office, I learned that there is no prospect as it was accepted by my appointing authority. So I learned from the head of the office that I have no prospect. So I submitted a letter for VR in the afternoon at 6 p.m.
But that you have not said in your application, that under this circumstance I am doing this. You are only saying, like earlier on one occasion you have said you please process, again you are saying you please process. You could have said that, look, I have come to learn this under the circumstance with no choice, I am doing this, but you have not said that. That's not your case. Even if that is correct, and if you have accepted the situation, then why you have again gone to the trial? Just because they have accepted in the forenoon, if you have given the application, then why are you challenging?
My lord, they have the department has given me VR and under a inapplicable rule 48(1)(a) that signifies 30 years of service. But I had applied for 20 years of service in my letter dated 29/11.
They are not under 48(1)(a), they are under 48. Yes, 48.
I had applied under 48 capital A, which after rendering 26 years of qualifying service in the department.
Qualifying is 20.
20, my lord. But department accepted it in a separate rule, inapplicable to me, that rule signifies 30 years of minimum qualifying service.
Let us see, where is the CCS pension rules?
And that does not require any acceptance.
May I hand it over the book, my lord?
Yes. We have it. We have the CCS pension. 50 বলেছি the pension scheme. CCA's pension, the CCA leave rules. Been quoted, it is not that the power is not there. The power is there with the authority. Whether it is under 48 capital A or 48 1 small a, it is not that the authority does not have the power or that you did not have the option of making it under the rule. You had the option. So if the rule has wrongly been quoted, that will not invalidate the order. This law is settled by the Supreme Court. If the authority has the power and there is a specific provision conferring the power, then because a wrong provision has been quoted, that will not invalidate the order. The power existed. If not under 48 capital A, it was under 48 1. So they had the power. And even if they didn't have the power, since 1st of March till August, what you were doing?
Madam, my lord, I went to the senior DDG's office in the Dak Bhavan, the headquarters of Department of Post. There, they called me and they asked me that why did you give VR? I told
why did you
tender your VR applications? I told sir, I withdrew my VR on 23rd. Senior DDG Postal Accounts and Finance, my lord, and I told him that I withdrew my VR on 23rd of February. After that, it was accepted on 28th of February, after a gap of 5 days, and after the notice period of 90 days.
No, not after notice period. It's not after notice period. It is not after notice. How it is after notice period? What is the date of your notice?
Date of my notice
22/11, 28/11.
29th November 2021.
29 November. Then
I withdrew on the 87th day, my lord, and I was given VR orders on the 92nd day.
If the resignation according to your application was to take effect on 1/3, that is the date you have given.
1/3.
So there on 1/3 they have accepted it. Prior to 1/3 you, and therefore again we are asking you, why did you not immediately tell the authority? Why you waited so long and then you have approached a tribunal? Does that tribunal have jurisdiction? How it can deal with the matter? Where the order was passed?
20th December 2024.
The order of 1/3/22 was passed where? By which authority?
By Member Finance Department of Telecommunications, my lord.
Where?
Page 67.
At Delhi.
At Delhi.
headquarters of DOT, Department
From
of
there it has been communicated.
Yes,
But,
my lord.
but at that time, where were you posted?
I was at Ranchi. And my lord, another thing,
No, this is CCA. CCS pension, not CCA. CCA we have here. This is the CCA. Ask then why one should be here also. One in chamber, one here. Get for. So if you are posted in Ranchi, how you could have filed the case here in Calcutta?
my lord, I
There is a
returned back home. And for last 38 months, I am facing extreme financial hardship because I am not getting anything. I have not accepted retirement benefits till date.
They have not submitted the form. Form are already supplied from the department to the respondent. But respondent did not fill up the. And whether it appears from the reflection of the letter, here's letter, various types of letter, my lord. First letter 29, kindly see. Mother's death, family trouble due to my illness. Then prayer on second prayer, my lord, kindly see. ওটা আমার, ওটা আমার।
According to you, it is under 48A.
Yes,
So
my lord.
48A4. Let's see what 48A4 says. What does it say?
My lord, it can be applied after 20 years of minimum 20 years of qualifying service.
That is not the. Yes, you have come with any judgment. What is the law? Where is any judgments you have got on this point?
Judgment, my lord, they have cited, the tribunal has cited the judgment on judgment reflected, my lord, the Fajuluddin versus Union of India. This
Where is
judgment
that?
does not tally.
Where is it?
Paragraph 3 in the tribunal's judgment.
Where is the judgment?
My lord, I have
Having the soft copy,
soft
Lordship,
copy, my
because
lord, that is it.
I'm not having the hard
You
copy.
give him copy.
Lordship, it was.
That is a one time that petitioner here in this case, my lord, the petitioner have applied for BRS and subsequently withdrew. My learned friends, my lord, the three times it and accepted. I'm not kindly see the first letter 29th, my lord, kindly see page on 29th letter, my lord, kindly.
Why should we look at the same thing again? Show us the law. We have heard everything.
I have been affected.
We have heard everything. You show us the law. You come with the judgment.
Yes, my lord, on
Come.
Friday or
All right. The Learned Council for the Union of
Number 17.
Yes, who is appearing? Who is appearing?
I understand Mr. Sudeep Krishna Dattu is appearing through online. Video has come, audio is not coming.
See what is the
সুদীপ তোর অডিওটা অন কর। আচ্ছা তো কোনো অন করা আছে, অডিও অন করেছে।
What is the date of charge memo?
In this matter, I'm for the appellant. Mr. Indrajit Dasgupta is addressing in the court number 41
You are for the,
for the Appellant Union of India.
who is he appearing for?
Mr. Indrajit Dashgupta, he is addressing
But
in court
Mr.
number
Dotto
14.
possibly is appearing for the applicant before the learned tribunal.
No, she's saying Union of India. She's saying Union of India.
না ইউনিয়ন অফ ইন্ডিয়ার তোমাদের পিটিশনটা কি আছে Yes, my lord, Mr. Indrajit Dashgupta is representing Union of India. He is addressing court number 41.
So
And Mr. Dotto is appearing for the applicant before the tribunal.
Oh.
He is my lord the private respondent.
we thought he was representing Union of India. But not today, ask him to come.
Item number 18.
এটা দেখুন 9 তারিখে ডেট দেওয়া আছে বোধহয় My lord, in this matter, my lord, notice has been given for 9. Notice has been given, my lord, that the matter will be moved, my lord, or appear in the list on 9. The issue is land loser, my lord. My lord, a few days back, my lords have decided WPCT 119, my lord, of 2023. My lord, unfortunately, the present petitioner here could not put his signature in the Wakalatnama. As such, his name did not appear. Subsequently, he made an application in connection with 119, my lord, for addition of party. That's addition of party, since the honorable judges who were taking the matter was not inclined, it was dismissed as withdrawn. And that this separately, my lord, that's why it has to be filed. My lord, since my lord, the other side is not there, my lord, may it be not today because notice was given for tomorrow.
At least inform the learned counsel. You please inform him.
And I do not know who is there. Still, my lord, I'm trying because my lord, the concerned respondents have been served. I do not know who has been engaged in this matter, my lord. It's railway. I don't know. Normally appears. I shall try to assert.
Let us see, not today.
Item number 19.
May I please, Your Lordship? My Lord, we are the applicants, petitioners before Your Lordship. My Lord,
You approach the tribunal for what relief?
My Lord, we had made an application before the learned tribunal seeking, my Lord, orders for refunding amount that has been deducted from the salary of the petitioners who are the, Your Lordship, casual laborers under similar circumstances wherein certain other persons who were working along with the petitioners, their application was considered by the tribunal. Tribunal directed the state to refund the amount that has been wrongfully deducted. And
Why the recovery has been effected? What is the reason that they have assigned?
Pardon, Your Lordship.
What is the reason they have assigned for making the recovery?
Yes, Lordship. They said that certain notification has been issued, but we were drawing our salary pursuant to notification date of 2009. My Lord, we are withdrawing our salary. And subsequently, they said that subsequent notification being issued in the year 2010 and 2011, by which we are not entitled to the amount that we are withdrawing. So we had withdrawn excess amount which we are entitled to refund. And without even prior to issuing any notice to us, they started deducting the amount. And when we came to learn about it, Your Lordship, a notice was given to us that we are entitled to refund the amount. We made representations before the respondents that you are not entitled to, as we are withdrawing our salary pursuant to the slab what we are entitled to. Because the petitioners before Your Lordship, they are the casual laborers working as a whole day workers and throughout the year. for 365. Your Lordship. Your Lordship would be kind enough to take the first annexure. My Lord, this is at page 43. My Lord, it would be evident, Your Lordship, that the number of days
What is the period from which date to which date?
the amount that been deducted.
No,
My Lord,
the excess payment you have received till 2016. But if from which year, which month?
yes, Your Lordship, that they have stated.
The
Your Lordship.
notification is 20th May 2009.
Annexure I, that is at page 91.
Give us the date, sir.
Yes, Your Lordship.
From which date to which date?
You have,
Lordship, in
they have
item
alleged
number
that you have
19,
deducted
20
amount.
and-
Wait, Your Lordship. I shall go to- From 1/5/2010 to 29/2/2016.
And what do you mean they have excess withdrawn? They could have withdrawn without your. How these casual rated employees could themselves withdraw any money?
Not that is what they have stated. My Lord, as we are entitled to, as per my Lord, Annexure H. My Lord, kindly turn to page 90. This is the memorandum of 20th May 2009. We are getting our payment as per this memorandum. My Lord, kindly look into take the first one. If employed whole time and throughout the year. My Lord, the petitioners, as would be evident for my Lord, Annexure A, that these peoples are working as a whole timer and throughout the year. For them, the payment slab is this: pay in the pay band scale of rupees 4,900 to 6,200 PB1 with grade pay of rupees 700 plus allowance as admissible to whole time government employee. My Lord, it will be evident, my Lord, from Annexure P1, the first annexure, Your Lordship.
The date of the order by which they directed the recovery.
My Lord, that annexure, the next page, Your Lordship, page 91. 23rd of December 2016. Annexure I at page 91.
Yes.
Mr. Mukherjee, Tapan Kumar Mukherjee is appearing in this matter. He's out of station. I am praying for not today only.
Yes. Let him be here. Not today.
We served, Your Lordship, the affidavit of service.
What are you serving?
Affidavit of service we served. That's all.
We'll take it tomorrow.
Yes, yes.
We can.
Number 20.
Time for the petitioner. Lordship, in item number 20 and 21 also, Mr. Mukherjee is appearing in this matter. I am praying for not today only.
Let him be.
21, I am for the petition.
Tomorrow, sir, tomorrow.
Item number 22.
We need to appear for the petition led by Mr. Carlos.
Millard 9/10/2018, Millard, an advertisement was issued by the West Bengal Health Recruitment Board for the post of Inspector of Drugs, Directorate ISM Drug Control. Now, Millard, three posts. Number of posts was 3. 2 for Millard.
Inspector of Drugs.
Yes.
3 posts.
3 posts. 2 Millard reserved, unreserved for the OBC.
1 unreserved.
Unreserved.
And you are claiming
unreserved, unreserved 2, 1 SC. Unreserved 2, 1 SC. Total number 3.
And you are claiming against?
I am claiming against Millard unreserved. Now, Millard, what happened? Millard, they verified Millard my eligibility criteria. I was shortlisted, called for the interview, everything.
Drug inspector by interview?
Yes. Yes. I Millard, I was shortlisted. I qualified, Millard. And then, Millard, what happened?
This is contractual.
No. Direct recruitment, Millard. Recruitment board, Millard. Recruitment published.
Recruitment being done just by interview?
No, written. I said, Millard, the eligibility criteria as advisor petitioner had submitted requisite. Then, Millard, I was shortlisted and called for document verification for interview. And I was allowed to appear and perform the best of the ability.
There was written test also.
Millard, written test also, Millard. I also appeared in the written test. If it is, Millard, only on the basis of the interview, Supreme Court said cannot be done. Of late, Millard. And Ashok Jadhav, 1987, also said that is with regard to the percentage of marks. That if it is 200, Millard, no, cannot be more than 12.5. Now, Millard, of late, Millard, I have come across a judgment subject to correction, Millard, presided over by a bench Justice Dotto, Millard. It said the selection process only. And, Millard, in this case, Millard, the petitioner, Millard, after verification, he was shortlisted for interview. And, Millard, he was not called for the written test. No. Because there was the provision for written test.
Written test must be preceding the verification and interview.
No. That is why I am requesting your lordship to take note. 9/10/2018, advertisement published.
Yes.
3 posts unreserved to SC1. Then, Millard, they verified that my eligibility criteria, my certificate, everything. I was shortlisted on 8/3/2019.
Yes.
Called for document verification, come interview on 13th March.
Shortlisted in which process? That is what we are trying to understand.
100 marks exemption.
Oh, your lordship is saying that whether written examination, it is preceded by interview preceded.
Yes.
Oh, I see. I'm sorry, Millard.
Must be.
Yes.
It can't be the other way around.
Yes, Millard. That is true. I'm sorry, Millard.
Yes.
Then, Millard, notice was issued by the Joint Secretary Health, 99 candidates who had been recommended by the West Bengal Health Recruitment Board. 26 July, Millard, I came that the memorandum was issued by the Department of Health. They said, Millard, containing the panel of the petitioner name was absent. I have, Millard, perused and I found that in terms of the advertisement, there were 2 vacancies in the unreserved category and 1 vacancy in SC category. 2 candidates belonging to OBC-B and SC category respectively were recommended for appointment against 2 vacancies in the unreserved category.
2 candidates?
For unreserved category, OBC and SC, OBC-B and SC. They were recommended for the unreserved category. When I filed a case, Millard, original application before the tribunal.
What category they were is hardly relevant. What is their performance? That will have to be seen.
I don't know. Only an unsigned written instruction was taken up. When the matter was taken up for consideration, tribunal was favored with an unwritten, unsigned, Millard, a written instruction without any affidavit. Only on the basis of such written instruction, tribunal, Millard, disallowed my claim. And, Millard, the first time I came to know in this curial combat, that is for the tribunal, that I did not, Millard, submit documents. Millard, it was expected from the Honorable Tribunal that at least an affidavit, they should have called for affidavit. It should have called for affidavit saying that what are the documents that were received by them, Millard, while finalizing the panel. Nothing was there. Kindly seize the judgment.
Kindly seize the order impugned one.
There is no opposition filed by you before the tribunal.
No. Only on the basis of the written submission.
And how the tribunal can proceed like?
Kindly seize the
Later.
order once. If Lordship will direct, we will do it. Kindly seize the order once. and the advertisement which has been shown by my learned senior friend, distribution of marks, and why his candidature was rejected.
Yes.
Kindly see the impugned order. Last few pages. In the crux, Lordship, 2 or 3 lines, if I may be permitted to. At the time of document verification, the applicant was found not eligible due to non-submission of essential qualification certificate, which is the practical training experience in Ayurvedic Siddha Unani. Accordingly, his candidature was rejected.
What new thing he has said? What new thing she has said?
In simplest words.
What new thing she has said? I said that I did not.
But this
and Millard kindly sees the understanding of the tribunal.
Distribution of marks also you have to show, no?
No. The tribunal has examined the statement of the Secretary and Controller of Examination, which records non-submission of essential qualification certificate, practical training experience in Ayurvedic Siddha Unani. Accordingly, his candidature was rejected in absence of any evidence presented by the appellant side. Although, my lord, I have submitted categorically that I was shortlisted and called for document verification come interview on 13/3/2019, page 42. My lord, this submission, she is properly not, she has not been correctly instructed.
I have been correctly instructed.
My lord, kindly sees.
Probably you have not been.
42.
No, that is whatever it may be. When they have made out a case, at least they were required to be served an opposition and given an opportunity to rebut these whatever you have said. Merely because some statement from the secretary has been taken by the tribunal and on that basis.
I do not know, your lordship, but that definitely must have been a signed statement. It's something which cannot be signed, cannot be, as far as my common sense goes. Definitely those instructions may be taken on record only and only if there would have been.
No, even if it is signed, I take her that is true, Millard, even it is signed. Sorry.
Yes.
That definitely might have been a signed document, your lordship. I was not representing the state over there.
So let us know what is the state of things. Maybe there is a statement after due service upon them, the tribunal has taken it.
I'm agreeable to whatever falls from your lordship. Not once have I denied, but it is my.
What is your case in the way?
My case in the way that that my name was not found, Millard, in the panel. And I said, Millard, there was categorically said my representation.
What is the date of the panel?
Advertisement first kindly to explain. Page 37.
P1, your lordship.
Page 37.
P1.
Inspector of Drugs, you are 2, SC1. My representation is at Millard, page 55.
You have
That kindly comes to Millard, page 56.
No, where is the original application?
Original P1, Millard, that is at, it starts from
that is the
page 21.
Annexure. Oh, page
21, Millard, it starts from page 21. And my prayer, an order directing the respondent, which is at page 34 of your lordship's brief, respondent and set aside the panel of persons such and such, an order asking for a fresh list of persons who have qualified for the post of such and such, dated 9th October. And also, Millard, an order directing the respondent to disclose the minimum cut-off marks for the qualification to the post of Inspector of Drugs under the Department of Health. When such, Millard, decision was taken, whether, Millard, the rules of game changed, Millard, after the selection process commenced, we do not know. There is no element of transparency, Millard, anywhere.
What is there? 20 marks for 10 plus 4. 20 marks for degree. 10 marks for postgrad. 50 हो गया. Then professional experience 585. Should be sufficient. So there is no examination.
Kindly see page 40.
No examination.
That's what we are looking at.
Distribution of marks.
There is no examination. 20 for 10 plus 2, 50 for degree, which they say you don't have. 10 for postgraduate.
No, they said, Milord, I did not submit my credentials.
So you didn't submit, that means you did not have according to them. You may
According
be
to
having
them.
it and not submitting it.
Correct. Milord, but I categorically said on 13/3/2019, they called for me for the interview, Milord. That was document verification. That was done. I
Document
was
verification of documents submitted.
Yes.
Yes.
Yes, but this is not the case. 8th March 2019, Milord, when I was shortlisted, called for document verification. Milord, after that, Milord.
Where have you said this? We are trying to find it. Where have you said this?
Milord, first of all, Milord, I would like to take my Lord's kind attention, page 42.
Come to the OA. What have you said? We are trying to see what your
OA,
client's
Milord, it
case.
starts from 21.
Yes.
Milord, way I did not make out.
What
Milord,
is your client's case? Let us see.
Milord, way in OA, the first time after this was taken up for consideration, first time they said, with regard to Milord,
Forget about what they said. We want to see what you have said.
I
What
have
is your
said-
client's case? Let us see.
Yes. Page 21, it starts, Milord.
Yes. Applicant applied for the post upon going through the criteria. That's all right.
Yes. Milord,
Was
my
shortlisted
case is
and
based on.
document verification call interview letter was issued. That's all right.
Yes.
Before the document was cross-checked, verified, returned to the
I submitted all the applicant had given his level base, followed all the guidelines, interview in the notice date 26, published. The applicant was allowed to appear before the interview. During the interview, the applicant duly furnished all the relevant documents and followed all. These particular statements needs to be Milord controverted.
No, but what is the stage on which you are supposed to give the document, not after the interview?
No,
you
on the
say after the interview we have given everything, or at the time of interview?
I did not say so. I said
at
during
the
the
time,
interview.
during the interview. So is that the stage? Let us see the advertisement.
Yes, advertisement.
What does it say when the documents are to be submitted?
It starts from 37.
Yes.
Applications are invited from Indian citizen and such other national as declared eligible by Government of India for recruitment to the post of Inspector of Drugs in Control West Bengal Service, Government of West Bengal. Online registration will be allowed to the website such and such. Posts are temporary but likely to be permanent. The relevant rules and necessary particulars are stated in the following. Then Milord,
not read the entire thing. We are trying to find out where the procedure is laid down. Just let us see. You also see. Don't read
Milord, this is Milord said. Milord.
Page 38, Your Lordship, towards the bottom. Candidates must fulfill the essential qualification by the closing date.
Yes.
That is not the question, possibly.
That is our question.
Question is,
Does the procedure leave the scope for you to carry the testimonials at your interview, or they are required to be submitted before the closing date?
That is, Milord, in page 42 possibly is the answer.
Yes.
Before coming to the documents verification come interview, you must ensure that you have to fulfill all the conditions of the eligibility criteria for the applied post advertisement. You are requested to bring all original documents along with 2 separate sets of photocopy original of the following in the same order. After verification, they shall be returned. I said, Milord.
Page 42.
Page 42. Because it starts with the sentence where documents come verification, come interview call later.
Yes. You file an affidavit, then we'll see. Let the Learned State Council file a
Number
Yes.
23.
What do you want to say?
No,
Tell us.
he said, no, he said, Millard, he was asking for, no, he said, Millard, that the first time a new plea has come in the tribunal, and tribunal, he said, Millard, initially I made submission that it was unsigned. He said the authority secretary may have signed, but question is only on the basis of this written instruction. I didn't know.
Here it is, we find even in court, we are taking documents as far as it is served and an opportunity is given to rebut. If the document is accepted, we don't know. That's why we said, let them file the affidavit. Maybe they have served a copy of the written instructions and it was with the lawyer. Maybe he has not opposed. We don't know. You are not appearing there.
None of us, even I was not there.
So therefore, let us see what they have to say here.
Lordship has given a date,
Yes.
13th, 1-3.
But in this matter, I appear for the petitions.
Lordship, I am praying for not today on behalf of Mr. Tapan Mukherjee.
But trying to make it all not your state.
I'm so child.
So kindly take it up on 5.
No, why?
Tomorrow there is a resolution. My lord knows, my lord Justice Justice Somaros Banerjee has passed away.
So tomorrow's matters will go on day after tomorrow anyway. Why should we fix it?
Day after tomorrow, kindly take
No, not today.
There is already a resolution.
We have understood, sir. Don't worry.
As your lordship.
Grateful.
24, lordship. I am for the petition, lordship. Service has not been effective, lordship.
Service is not required. Make out a case. We'll see whether they are required to be summoned or not.
Accommodation only.
Why?
For the instruction, lordship.
What instruction? You have filed without instruction. Let us see. What is the issue? What is the issue? Come to the issue.
For the appointment of a lordship, may I do not have to brief.
Why are you here? This is not the way to appear. Sorry. Not today. Ask him to be here tomorrow. No, sir. No adjournment.
Not possible, lordship.
Not today.
And bring back the
Not today. Come tomorrow.
lordship. 25.
That But I undertake to file the another copy, my lord, the affidavit of service. Only one copy is with me.
Today itself.
Affidavit of service.
Today itself.
Yes. Today itself.
Yes.
My lord, the petitioner, now he is posted at Bakura as a special revenue officer. The case before your lordship is this 7/1/2023, 13. My lord, my client received a show cause notice. And my lord, the allegation was this, that he revived a relevant record of rights and altered the record of rights without my lord taking any prior permission from the higher authority. My lord, then my lord, my client, my lord, requested the authority to supply me the relevant copies. My lord, no copy was provided.
No charge memo, only show cause.
Show cause. Then my lord, what happened? There was granted directing my client, my lord, to take a pencil note from the the documents.
To take a
pencil notes
from
the documents that was the office.
So inspection was allowed.
Yes, inspection was allowed. But my lord, I could not submit my reply because they denied the opportunity to inspect the record in question for whatever reasons. I categorically stated. Charge sheet was issued after 1 year. 14, 24th February 2014. My lord, I submitted my reply. My lord, I initially participated in inquiry. Ultimately, I suffered a cerebral attack. And ultimately, my lord, 16th May 2018, a punishment order was served. Punishment order, my lord, reduction of pay of stage 2, lowered in current payment stage for a period of 2 years.
One stage.
2 stage.
2 stages for 1 year.
Yes. Inquiry report, my lord, was not given to me. I, my lord, second show cause was also not given to me. My lord, I question, my lord, the order of punishment by way of filing a original application 1032 of 2018. It is still pending. On 3rd May 2021, after 3 years, my lord, the authority had issued another show cause notice cancelling the earlier order of punishment dated 16th May 2018. After 3 years.
They have cancelled it.
Yes. They said they issued a show cause saying that the earlier order of punishment that has been cancelled. My lord, yeah, because there was a procedural impropriety.
Who said? The appellate authority?
No, disciplinary authority. The disciplinary authority imposed punishment on 16 May 2018.
And he himself said that it was.
Yes, my lord, said, recalled. After 3 years. Second show cause, this was not given, inquiry report was not given. I did not get an opportunity to respond to such. Second.
But then he said that it is not, he has himself held it is not in accordance with procedure.
Correct.
So that is, all that is washed off.
Yes, that is good. That is gone. Now, my lord, on the same charge, my lord, it says show cause notice was given and disciplinary proceeding. And my lord, the first time he supplied a copy of the inquiry report and submitted, and I submitted my response.
No. So the second time there must have been a fresh charge memo, or it continued on the earlier charge.
Continue.
So on the basis of earlier charge memo, inquiry officer again proceeded with the matter. This time inquiry report was submitted.
No fresh inquiry. The only, my lord, that the punishment order set aside. Then, my lord, supplied a copy of the inquiry report and asking me to respond.
So from that stage, from that stage,
right.
supply of inquiry report.
Right.
All right.
My lord, I deeply obliged. My lord, disciplinary proceeding, my lord, has not been concluded till date. Thereafter. I, my lord.
So they supplied a copy of the inquiry report when?
My lord, 3rd May 2021.
And then you responded.
Yes.
The inquiry report was.
Inquiry report was supplied. I responded.
Holding the charges proved.
Charges proved. Charges proved. I made a representation, my lord, that I have crossed 25 years service. So MECS benefits to be given to me after completion of 25 years of service. And such prayer was forwarded to the appropriate authority. And ultimately such benefit was extended to me. Then now, my lord, kindly. My lord, since the promotion was not given, I filed another application, my lord, way number 5155 of 2022. And then immediately thereafter, my lord, on 19 July 2022, I had received a punishment order issued by the Land Reforms Commissioner. Punishment of reduction of pay to 2 stages lowered in the current payment for a period of 2 years, including debarring of promotion for such period.
So same punishment.
Right.
No, including debarring of promotion also.
This is the additional, my lord, punishment that was imposed. My lord, to that my lord, my submission was this, that this part was not engrafted in the second show cause. The show cause, my lord, that was given after setting aside the punishment on 3/5/21, my lord, the nature of punishment to be imposed upon me, that should be, my lord, written. But this additional punishment, 2 years including debarring of promotion for such period, this was not engrafted, my lord, in the notice, show cause notice, which was a sequel to the setting aside of the punishment on 3/5/2021.
No, 3/5/21 is the inquiry report.
3/5/2021 is a memorandum issued by the authority. Another show cause notice cancelling the earlier punishment order dated 16/5/2018.
But just now you told us that inquiry report was supplied on 3/5/21.
It was enclosed with that, and I was asked to respond.
Where is that? Let us see. 3/5/21. Page 59. So that was not a proposed punishment. The debarring was not a proposed punishment. That is what you are saying.
I said you cannot travel beyond the scope of the shokas. Whatever you have written, you must be confined.
And that lapse to mention the consequential or whatever additional punishment, that will vitiate the entire thing.
Milord, that is, I would say it is a kind of a, Milord, procedural impropriety, and such exuberance, Milord, in a way, Milord, contains an element of bias. Because when you made a shokas, it is expected and presumed that the authority applied its mind, that I have formed an opinion. Initially, prima facie, I am giving a shokas.
And this is under which procedure? WBS CCA rules.
96,
WBS
97, Milord.
71.
Yes. 71 regulation, Milord. West Bengal service.
WBS CCA rules. That is why we are saying
CCA rules.
WBS.
71.
So, what did you do?
No, I said, Milord, that here, Milord, I am confining myself to the two things. One is, Milord, the MCS benefit that was given to me after completion of 25 years. Suddenly, Milord, on 29,
MCS benefit means
Modified Career Assurance Scheme.
MCA. Okay.
MCS. Milord, this was given to me. Authority, Milord, referred. They forwarded, Milord. I categorically said benefit was extended. Page 82, Milord, if your Lordship kindly sees.
What is page 82?
82, Milord, is the order conferring me the benefit of 5 years. First line. Such and such, Nur Muhammad, under section, completed 25 hours service with 2 promotional benefit during his service career as he entered government service in the cadre of WBSLRS in the forenoon of such and such. This benefit was conferred upon me.
Yes.
Now, Milord, and third is, hence in terms of geo number such and such, his pay is hereby finally fixed for allowing, yes, with effect from, Milord, 5th October 2018. Milord, 16th May 2018, the order of punishment was issued first. 21, Milord, it was set aside. And then this was conferred upon me.
Yes.
Now, 101, date is, Milord, 7/7/2022.
Yes.
Before the punishment order was imposed, punishment order was given, imposed on 19/7/2022.
Where is that?
Page 83, next page. Then, Milord, the last line, page 84, with a further direction that the charge officer be debarred from promotion during the period of such and such. Such debarment should not be treated and imposed as a penalty. This takes us nowhere, Milord. This makes no sense. Subject to correction, Milord.
If they had not mentioned this, would you be entitled to earn any promotion in this period?
Milord, I rely on a judgment of your Lordship's coordinate bench. Circular is also there. Milord, I will come. And Milord, after the, before that, Milord, if your Lordship kindly permit, Milord, page 101.
What is this at 101?
101 is the order dated 31st July 2023.
Yes.
It says, Milord, that the impugned, it was the impugned order because this MCS benefit was awarded to my client, but he was not entitled to receive the said benefit as criminal proceeding as well as departmental proceeding against him.
This is not as a result of the punishment. This is not as a result of the punishment. This is at the time of subsistence of a departmental proceeding or criminal proceeding, whether it could have been granted or not.
Well, now, Milord, this was done, and before that, the benefit that was conferred upon me, the money was given to me, and suddenly, Milord, this order, Milord, 31st July 2023, 19th July, the punishment, as a sequel thereto, it's a knee-jerk reaction.
That we have seen. So whether this is sustainable or not, This, you had assailed this order before the tribunal.
Yes, I assailed this.
So what is the, tell us, what do you have to say about this?
Now, my lord,
This has nothing to do with the punishment.
no, this was not. But this was, my lord, taken away. Now, my lord, kindly seize the order circular.
Which circular?
Calcutta 28 March 20. This is, my lord.
On which point?
2 to 4. Just a minute. Calcutta 12 June 1980, which was question of confirmation of promotion of government service whose conduct is under investigation or against military appointment proceeding.
Oh no, where is the MCAs? It has to be in the MCA. This is a benefit under the MCAs. So MCAs must be saying that during pendency whether it can be granted or not. Let us see the MCAs. This is not a promotion.
No, it is not.
It is not a promotion in the
Correct,
stricter
correct,
sense.
correct.
So where is the MCAs? Let us see. That will unravel whether they have the authority to do this or not.
Milord, this circular is not with us, Milord, but this is the, I said, Milord, the benefit was conferred and Milord, it was withdrawn.
We have seen that. They say that this is a circumstance in which it could not have been granted, therefore we are withdrawing it.
Right.
First thing is whether that is a correct premise or not. Second thing is, even if that premise is correct, can they do it in this way?
Yeah,
So let us see whether
and
MCAs
yes, Milord, the honorable tribunal has relied on the circular of the government. Kindly seize the impugned order, Milord.
Forget about it. Let us see what is the. We have to be
set. Yes, yes. OMCA circular, Milord, I need this time.
It's not in a book. MCAS is not in a published in any book.
The circular, which I wish to rely on, Milord, that is not with me, Milord. At present, I have a different circular.
No, where is the circular notification, whatever it is,
circular
notifying the MCA scheme? Where is that? Must be there in some book.
Milord, this is, Milord, it is not in the, your lordship will not find in the, Milord, there is a specific circular issued by the government. Executive instruction. Finance department has, Milord.
More or less same in every state, but then there is a small publication containing the MCAs, which is
circular, Milord.
You have it?
Today it is not there, Milord. My client, Milord, he has shown me, but the tribunal has gone on a different premise.
What the tribunal has said?
Tribunal said, Milord, 31st December 2024. Welcome. 13th December. He's understanding. Milord.
So he has relied upon the CAS and MCS.
No,
He says integrity clearance is required.
He said, Milord, Milord, the government has indicated a 22nd September submits in the 3rd page. Mr. Sarkar further draws attention to memo dated 22nd September 1992 and submit that as indicated in this memo, integrity clearance is compulsory for employee to become entitled to receive benefit of higher scale and other benefits under SCAS. This memo under reference has also cited the memorandum of such and such, which was earlier presented by Mr. S. Banerjee. Mr. Basu has vehemently opposed the submission made by S. Sarkar that the applicant had resorted to some dilatory tactics during the proceedings. The order passed upon the incumbent does not speak of any dilatory tactics so claimed by Mrs. Sarkar. Having heard the submission of the learned counsel and the departmental representative and perusing the documents submitted by them, the tribunal has come to the finding that the initial order, punishment order dated 16/5/2018 was withdrawn in a second show cause notice dated 3/5/2021 issued against the applicant in connection with the departmental proceeding, which eventually culminated in the final punishment order dated 19/7/2022. Dated 12 June 1980, which both sides relied upon, clearly suggests in para 2.3 that promotion of in-service candidate to higher post should be held up where the disciplinary proceeding is pending against a government servant. It is also well settled position that for granting benefits to any government employee under CMS, CS, MCS, integrity clearance is required to be taken from the vigilance wing of the department or from the cadre controlling authority to ascertain his or her unblemished record for determining continuous satisfactory service. In this case, when MCS benefit was awarded to the applicant in 2022 with effect from 5/10/2021, disciplinary proceeding as well as criminal proceeding was very much pending against him, which clearly indicates that he did not have such unblemished record. It was not proper for the respondent district authority to grant MCS benefit to the applicant without taking approval from the administrative department.
Therefore, we are saying we have to see what is the MCS, what does it contemplate, It is to be given by the
But we are
field
trying
officer.
to Milord, get hold of it by day after tomorrow. And the state, Milord, if your lordship kindly request, Milord, the state, because they have the publication, Milord, in their custody.
So these things are not available for lawyers, published by the state.
So I will search, Milord. But
No, I'm just trying to understand, because I find that even in
it is not made for the public. Many a things, Milord, the government publications are not available, Milord. Even no, Milord, even if I require, Milord, rules of business, which is also sometimes very essential for us to place, Milord, we do not get hold of this. Milord, if I get the particular memo number, then I can search it on the website. But website. But today, Milord, I will also search for it. But my client, he is not in here, not here, Milord. I will talk to him, Milord, because he told me. But this, I have a judgment of this Honorable Court Coordinate Bench, which says that the pendency of the criminal proceeding, which is beyond 3 years, then I am entitled. Departmental proceeding, sorry, Milord. The judgment is.
there a promotion is to be granted.
Milord, we do not follow sealed cover procedure, Milord. In the government of West Bengal, in the instant cases.
Therefore, we said this is a criminal case.
Criminal case is pending.
We don't know in that case whether charge sheet has been filed or not.
Charge sheet, Milord,
We can't say, we can't see from the order.
No, Milord, but the memo which I wish to rely on, 12th June 1980, the question of confirmation or promotion of government service whose conduct is under investigation or against whom disciplinary or criminal proceeding have been started, contemplate has been under review for the government for some time past. The government says.
Where are you reading?
Milord, I have. Oh, your lordship has written this. This one. This is a 1980 circular.
It's not required. It's not required.
But it touches upon, Milord, the question. It says
there are two things. Here there is a criminal proceeding. It is an ad hoc promotion.
Yes.
And we don't know whether charge sheet has been filed. Insofar as the law, whether during pendency of a proceeding after submission of a charge, no, a promotion can be granted or not. The law is very clear.
Milord, the logic is, Milord, 1980, Milord, that is the circular.
Under some circulars like MCAS, where it is time bound, it says that it will be granted irrespective of.
Milord, here, Milord, subject to correction, the government, Milord, after careful consideration, a decision was taken. The confirmation, promotion, efficiency bar, crossing, selection grade, appointment of a government servant, or recruitment of in-service candidates to higher posts should not be held up merely because inquiries are pending in the Vigilance Commission. This should be held up only when departmental proceedings have been initiated.
Correct.
Or when the Vigilance Commission has recommended.
So it is
then,
correct. It is precisely.
Then, Milord,
yes.
Then, Milord, then, yes, first point is goes against me.
Yes.
The confirmation, promotion, efficiency by crossing selection grade appointment of a government servant or recruitment of in-service candidates to higher posts should not be held up in cases where disciplinary proceedings have been started, have continued for more than 3 years, unless the delay in the disposal of the disciplinary proceeding is due to any dilatory tactics employed by the government servant concerned or due to the proceeding in a court of law started at the instance of the officer concerned. However, when confirmation, promotion, efficiency by crossing selection grade, appointments or recruitments of in-service candidates higher post is allowed to anyone against whom disciplinary proceedings are pending, it should be ordered to be on a provisional basis. The confirmation, promotion, efficiency by crossing selection grade appointment or recruitment in service candidates to higher posts should be held up in cases where the government servant has been placed under suspension pending disciplinary proceeding, or government servant has started criminal proceeding against such government servant in a court of law. The instruction contained in House Administration dated such and such, which refers to selection of officer for appointment to a higher administrative post or grant of extension or re-employment, remains in force. However, para 1(3) of that memo, which refers to selection from non-gazetted to gazetted post for the first time, should be treated as cancelled. Accordingly, the works or to the gazetted post from non-gazetted ranks occurring in para 2 of the memo should also be deemed to have been deleted. This order does not in any way modify the memo number 25th May 1976, which refers to premature retirement of government servants under rules such and such of the Service Rules Part 1. Millard.
So you told us in this state we do not follow sealed cover. How it is different from KV Janki Raman, what you have read?
That is true.
Not at all different. It can't be different. That is the law. Once a charge memo is issued, only here it says if it has continued inordinately and there is no fault attributed, then on a provisional basis.
That is, Millard, even
therefore we said here it is ad hoc.
Here, Millard, the judgment, Millard, which I have referred. Here, Millard, I am also praying that this.
That we don't know. You are granted the thing finally, and they have withdrawn it.
So I said, Millard, whether because there must be some basis, they Millard, without giving any opportunity. I did not, because when you have taken a decision which affects my rights, and on the not only that, there was a recovery also.
Where is the withdrawing order?
10. 101. I said that interim order should be granted to us, the recovery part. And this is the final order, Millard. This part, Millard, 25 years MSCS.
This order is of 23.
In the meantime, I came before the Honorable Court, Millard, bench presided over by Justice Tandon, Millard, their lordships, and we filed, Millard, in 23 also.
No, but you are saying the interim order today, after 2 years.
Final order, Millard, final order, this is the final order.
No, you said we should stay in the meantime.
No, I said, Millard, that this order, Millard, which I said, Millard, first of all, I paid ad interim stay. That was refused. I came before the Honorable High Court. The matter was remanded back. Then Millard government did not file affidavit. By this time, Millard, ultimately we reached to the final stage.
No, but it is finality of July 23.
But today the order was passed. There is 101. I immediately, and the original application is also disposed of.
But where is the occasion to pass an interim order today? That we are asking you. After 1.5 years, how can we? You said interim order, therefore we are asking. Let them file opposition, we'll see. Did they file opposition before the tribunal?
No.
Have you filed an opposition before the
tribunal?
No. Then you file an opposition. For filing opposition. You please try to find out if you can lay your hands. We would appreciate if you could give us a copy also of MCS.
Yes, Millard, I will. I will if I get. Yeah, and Millard, I will also make it a part of record also, Millard, in the reply. Yes. I will get a photostat copy.
The notification number or something. We'll find it from the net also.
If I get it, Millard, I will definitely hand over to the lordship's photos.
The same story everywhere. These state government publications are not to be found. They stop publishing.
If your lordship, my lord, if your lordships request the government bill or the advocacy, my lord.
No, he has given us so many compilations. He has done it whenever any issue has come. If he would have been here, Mr. Mukherjee, he very readily, in fact, in a good way, he makes a paper book kind of a thing and binds it and gives it to us.
He is possibly, my lord, armed with this MCS, my lord, scheme.
But lawyers practicing in the service law side, they don't have.
But because it is not made available for the public. Even if, my lord, I tell you, lordship, rules of business very important.
Yes, rules of executive business, they involved.
Even the vigilance manual, my lord, it also becomes sometimes very necessary.
So there is no local publisher which is printing these things.
But this, no, we did not find it. WBSR, the WBSR, my lord, the notification, the books which your lordships are having, I do not know whether it has been updated or the reflection is there or not. I don't know.
That may not be there. That will depend on the year of the issue or edition.
But
whether it has a revised edition.
The government must not update the online service also. It must be on the portal.
Online portal does not have all the.
It has incomplete. That it does not meet the needs. And it is departmental wise. I am told. Milord, it has not been published, Milord, I am told. But we are accustomed of this because many a times even the government lawyers are also not provided with this copy at the time of necessity. Milord. Suppose your lordships are confronted with any question and Milord, any problems and your lordships ask, Milord, very few lawyers, Milord, they have because we do not have any access. And this online service or this updating the portal, Milord, this is a reflection of Milord. It started, Milord, for the last 3 or 4 years. Before that, Milord, this is in this state, and before that, we are not having a very good service, Milord. Yes. And I was also trying to impress upon your lordships, Milord, that whatever may be the gravity of charges in a criminal proceeding, unless the charges are proved in a trial, Milord, everyone is presumed to be innocent. The 80, Milord, every trial, Milord, in Milord court, if there is more than 7 numbers of witnesses, Milord, it takes 10 to 15 years. Yes. Janaki Ram is also steering. Yes, on the last occasion in one matter, Mr. Mukherjee was showing Milord.
And that has been engrafted in that notification that you were reading.
Yes.
Precisely the same thing is engrafted in the notification that you were trying to place. It says there is one exception. If there is an inordinate delay, not attributable, then provisional basis it may
Milord, here, Milord, my the proceeding started from 2013, January. Today we are in 2025. Ultimately, Milord, 19/7/2022, and this was the conferment of MSCS.
But this became due to you much later. The benefit became due to you much later.
2018, Milord. 2018, the punishment was imposed 16/5. 3/5/2021, this was withdrawn. Second show cause notice along with the inquiry report. Then, Milord, immediately 31st July, Milord, the conferment was made, and then it was withdrawn within a year. I said, Milord, that you do not possess, Milord, the seal cover procedure. This ad hoc promotion, I do not claim that it is my absolute right. But the question is that if the proceeding, which is beyond my control, and Milord, another proposition.
And if an ad hoc promotion had been granted in the period during pendency of a proceeding and that proceeding culminated in a punishment, what would be the fate of the ad hoc promotion?
But the period which I served, Milord, in the post, because ad hoc promotion is not an not
This
research.
is not a promotion on a higher post. This is only a this is only a enhancement, scale enhancement under a scheme, probably to overcome stagnation.
But the moment Miller 19/7/2022, this was punishment was imposed. Suddenly Miller they Miller they came with this 101 page Miller which I've shown. I said Miller there must be certain procedural propriety Miller. You asked me to return the money. You have decided on my issue, and and Miller this is this Miller.
And what will you say if they give you a show cause?
No, I say
they are only relying on the rule. They are not casting any aspersion on you.
Lordship might say that it is an ideal formality.
Therefore, we are asking you, what will you say? You will say, no, I have got it.
No,
I did not misrepresent. They are not alleging that in any misrepresentation.
I said, Millard, then the authority, when decided to confer this benefit on me, Millard,
they should have been vigilant.
No, Millard, they were armed with all the records before them.
Correct.
And Millard, so it was a conscious decision. The authority did not say that at that point of time.
Therefore, they are saying how it has been done at the district level. That is what they are saying. Without confirmation, we don't know. That is why we said, let us see the MCAs. Whether it can be granted at the district level by the field authorities or there is required a confirmation
if that is not there, Millard,
from the department.
Yes, I know.
We don't know. MCAs, Mr. Basu, MCAs. We want to see the MCAs. Please give us a copy. Yes, we have. Please. You give opposition along with the copy of clear and legible copy of the MCAs.
Number 26.
I am appearing for the petitioner, my lord.
Lord, I am appearing for the respondent, my lord, the state is the petitioner. That I am praying for.
State is petitioner. So let us see what the state has. If we want to proceed further, we'll give you time.
My only prayer is this, my lord, allow us some time to conclude the DP, my lord, because the inquiry officer has already filed their report and recommendation, my lord, and we have already prayed before the tribunal, but I will not allow, my lord. Some time bound, my lord, that so that I can conclude our DP.
Oh, so on account of delay, the tribunal has interfered. Then we'll hear him. You are appearing. Give your name. You have filed a Vakalatnama. Give your appearance, Mr. So-and-so, Leonard, Advocate Sub.
Grateful.
Nowadays, number 27.
Item number 27 to 30, kindly make it not today. On account of
I'm for the petitioner, my lord.
Not to.
Grateful, my lord.
You are in all three matters.
No, my lord, only 27.
So 27 only. Yes. Next matter, let it be called.
Number 28.
Not today.
My lord, my senior is busy in 35.
Not today, not today, sir. Yes, not today.
Number 29.
May I please? The petitioner, my lord.
Not today. Let him be here. Mr. Mukherjee is not available today. Let him.
Item number 30.
30, my lord, I'm for the petition in this.
Lordship 30 also not today.
Let us start.
Very well, you may. Start but not finish. Yes.
Start, not finish.
Yes.
Your lordships, kindly have a look at the order passed by the tribunal on last 29 January 2025.
Yes, tribunal has found that you are a fence sitter.
Yeah. Now the question is whether I am fence sitter or the honorable division, after the order of the honorable division bench, there is no scope for interfering on the selection process. Now, my lord, I have
After order of the division bench?
division bench, they said that after the division bench order, there is no scope for interfering in the process. Now my humble submission would be before your lordships that I filed the original application on 31st August 2021.
It would pass for 2020. আমাদের ইয়ে ছিল সুপ্রিম কোর্ট অর্ডার অনুযায়ী আমাদের
That writ petition was decided when?
The writ petition
WPST
was
one.
that decided on
23rd.
no, writ petition was there.
What is the final order? Date of the final order?
The final order is on 18 September 2023.
18th September
2023.
2023.
23.
23.
And the way out of which it arises?
Yes, madam.
The writ petition must be arising out of an OA.
Yes, yes.
Now, what is the number of that OA?
17th, right?
17th.
OA was the 17th. No, 17th.
The OA ওরা ফাইল করেছে
In the year of 2017.
No, we are asking the number, sir.
OA number original, it was filed OA 1046 of 2017.
So that was decided in your in the favor
No,
of the
yes, that is the decided in favor of the other set of the
other similarly situated.
similarly situated persons.
And then the state came up in appeal. State came up in the writ petition.
No, the tribunal dismissed the applications. Then, my lord,
Therefore, we are asking the it was decided against the applicants. They came before the writ court. The writ court allowed. Then you approach the tribunal.
Yes, no. Before that, I approached the tribunal because, my lord, I approached the tribunal in, my lord,
23,
2021.
21. So after the OA.
No, after OA was decided in 18 September 2023.
No. Writ petition was decided on 18 September 23, not OA.
Initial OA was 2017. That was first taken up in 2003.
Initial OA was 2017.
Correct, but
now, my lord, the writ petition was decided in 2023.
18/9/23.
Yes.
Yes.
Now, my lord, I came before this court
in 21.
When the COVID period was going on, and in view of the Supreme Court's exemption, I approached this court, and my lord, there was no. My humble submission would be there is no delay, or I am not the fence sitter. That, my lord,
page 50.
Page 50, if your lord.
What is the date of the result? What is the date of the result of the recruitment process?
18 can
18.
In 2023,
we are asking you what is the result of the recruitment process? Date of the result.
Recruitment process, it was, my lord, the recruitment process, entire recruitment process was, my lord, the cancer.
because of the rule of the game, it was changed. What they made an advertisement. They made an advertisement while asking for the 100 marks. Now it was reduced 85 marks.
You are claiming parity with the petitioners of WPSC 120.
Right.
They have
Therefore,
been
things
appointed.
decided.
They have been appointed.
They have been appointed.
How can they be appointed in a process which has been cancelled?
Well, that was the direction of the Honorable.
What? That appoint them and cancel the appointment process?
Not cancellation. Not cancellation. The procedure which was adopted by the selectors.
Yes.
That was not correct. It was found by the division bench.
Still appointment was directed.
And thereafter, appointment was directed.
How it can be, sir? We find it rather unbelievable.
Page 50, if your lordships kindly have it.
The proceeding is not in accordance with law, therefore appoint them.
Yes, madam.
You are saying the proceeding has been found to be not in accordance with law and they have been done.
The panel was directed to be recasted.
So therefore we are saying.
Yes, yes.
So what is the date on which it was recast?
2020. Well, it will be subject to 2020, 20. I approached before.
Give the date. The date on which the panel was recast.
That date.
How it can be 20? They have filed away in 17.
I have.
They have filed away in 17. You just now told us.
Yes.
So they must be relying on a result prior to 17. How it can be 20? Impossible.
Because of the fact, well, the way was finally that was decided.
Just let us see. There is something amiss.
Page 50, if your lordships kindly text out.
Please give us the correct dates. We are asking you a simple question. The proceeding was initiated for recruitment. When did it culminate? You are saying the process was cancelled, appointment was given, everything. How it can be? It cannot be.
Madam, may I read it out?
Just please let us now. Now let us read. Then we'll come back.
Advertisement. Advertisement. Interview held. Some candidate approached the tribunal. ऑर्डर 28/7/2020
Yes, the appointment was done in 17 pursuant to this process.
I tell you, lordships. Interview held in 2017.
Appointment done in 2017.
The last appointment was given in 2023.
Last appointment was by the court's order.
No. Last appointment.
The three persons court directed to give them appointment.
Yes. Yes.
The last appointment by the authorities done in 17.
Not 17, 18.
No, sir, 17. It is only after they were appointed that those petitioners rushed to the tribunal that how they are being appointed and how we are not being appointed.
Now, my
So
lord,
from 17 to 20, there was no COVID.
not 17. I approached when the 21 before this court. I
So
said
therefore,
that
we are saying 17 to 20, there was no such thing as COVID. Fortunately, mankind didn't know that such a thing existed.
17 to 18, there was no COVID.
17 for 3 years.
Yes, my lord, now the question is, my lord, when the illegality was proved by the authority and authority considered, and even in 2023, one appointment was given.
Therefore,
So-
the issue is whether you are a fence sitter. That is the only issue. That is the only issue.
Whether
From 17 to 21.
and the question is, my lord, when I came before this writ court, praying for directions, this point was not taken at any point of time.
We will consider it. That is the issue to be considered. That is an issue to be considered. How it can be overlooked? The law is very well settled on this point.
Only the whether the fence sitters.
Yes.
I was a fence sitter or not.
Or not. From 17 to 21, what were you doing?
Well, that too, I have to place certain authority.
Let us see what authority you are placing. Show us.
Today I'm not placing any.
Tomorrow, not today.
Authority.
Not today.
Tomorrow there will be the problem. Because the-
Let us see if there is a problem. It will go to the next day. It will go to the next day.
Item number 31.
Item number 31, I'm praying for not to demand.
Yes.
31, I'm praying for not to demand.
Why? You are for the private respondent.
So, my lord, for the petitioner, my lord, Mr. Sukumar Ghosh is appearing in this matter, my lord. He has not come to the court due to his wife's illness, my lord. Kindly make it not today only.
You are for the petitioner and
I'm for the petitioner, my lord.
this has been filed by the state.
I'm for the petitioner, my lord.
Not today. You are standing on the petitioner's side.
Just
She is standing on the respondent's side. She is saying, I am appearing for the petitioner. Whole lot of confusion.
Number 32.
Lordship, Mr. Pradip Kumar Toravdar, learned senior advocate, is appearing on behalf of the appellant, my lord. He's on his legs before Honorable Supreme Court, my lord.
So before the Supreme.
Therefore, my lord, can kindly be fixed on Friday, my lord. Because this matter contains some urgency, my lord, which is why I'm praying for Friday, my lord. If it's
So urgency also and adjournment also.
as per your lordship's convenience.
Wonderful prayer. Adjournment as urgency and adjournment both in the same breath.
I beg your pardon.
So
my lord.
therefore, we are obliged to adjourn and keep it immediately on a 1 or 2 day after also.
Lordship, he's
What
coming.
is the order? Let us see. You are here. Show us what is the order. So many volumes.
MCAS, है ना? Arrears and MCAS. Oh, not briefed.
So what is so urgent? The tribunal has directed them to communicate the decision.
My lord, there is some urgency, my lord.
What urgency, sir? You retired in 13, approached the tribunal in 21. The tribunal has asked them to take a final decision. What is the urgency? How much time do you want?
Your lordship, with what it reflects from the order, one who is availing CAS cannot avail MCA.
No, but you have not communicated the final decision that you are required to do. See, as played list after 1 week.
Number 33.
Well, I am for the one.
Not today.
Not this week, let's Monday,
All right. As prayed by learned counsel for the petitioner. The doctor told me to keep sucking.
Number 34.
34, my lord, I am praying for not this week, my lord. Mr. Santipodo Pahari appearing in this matter. He has not come, my lord. He is out of station, my lord.
As prayed, list after 2 weeks. Yes, in presence of learned state, as prayed by petitioner's counsel.
Order is, lordship has passed an order?
Yes.
Yes. 22nd, na? 22nd April.
Many matters were adjourned.
Number 35.
At least 10, 12 matters were.
My lord, I am for the petitioner, my lord. Matter relates to the pertaining to the compulsion appointment. It is rejected by the tribunal as well as department concerned as well as the
Rejected.
Rejected.
On what grounds?
The ground, my father died in the year 1998.
98.
98.
Yes.
I applied immediately in the year 1998.
You are the son.
At that time, I was minor, sir, my lord.
You were minor.
Minor, at that time.
How did you apply if you were minor?
Through my mother. My mother prayed to the department concerned that the
How you could have been appointed being a minor? Anyway, so your mother applied for you. Then what happened?
to keep the service reserved for my son, minor son. And later in the year 2014, when I became major, I applied. And department concerned considered that one and given me direction to appear before the competent authority for the competency or for proving my efficiency. Written test, biography, physical efficiency and everything.
Written test for compassionate appointment.
Commercial. Physical efficiency. Like this police constable law. And Uvachi at this number, my lord.
In 2014, they have asked you to, where is that direction to appear in the written examination?
This number 54. At please. And it's at P6.
Then what happened?
You
appeared? You appeared?
Appeared.
Then what happened?
All of a sudden, when they have sent my name to the appropriate authority for approval, the competent authority, deputy secretary, assistant secretary, given or pass an order that in accordance to EMP 251, 2013, a minor is incapable. At the time of the death of my father, I was minor. That's why I have appeared before the tribunal.
So you were 2 years old at the time of your father's death?
3 years. 1995, my date of birth. And my father died in the year.
Why your mother didn't take the appointment? Why she did not take the appointment?
Super paper.
Why she did not take the appointment? She could have taken.
Eligible education qualification was that there.
Where is the application submitted on plain paper? Which application? 98, there was any time limit for making application?
No, there is no time.
No time limit in 98. There was no time limit.
There is no time limit.
Where is the application?
My mother's application is not here. I have not seen it. But so far, instructions concerned, my mother appeared before the authority concerned for her appointment.
What is at page 41?
Page 41.
Who is for the state? Who is appearing?
Page 41. After getting my majority.
Oh, this is the application after attaining majority.
Majority. And the first one is when my father died.
Yes, in 98.
98.
That you are not showing us. You don't have it. What is that page 39?
Page 39, my lord.
What is it? What is that?
That I minor.
That is?
That time when I applied, my father had died in the year 1998.
That is the 98 application.
That yes.
At page 39.
Page number 39.
You said it is not with you. Just now you told us that it is not with you.
My mother's application, I thought myself.
So in 98, your mother has only applied. You have not applied.
My mother applied on behalf of myself that my minor son will be resolved. আমার একমাত্র পুত্র কনস্টেবল পদে চাকরি দেওয়ার জন্য আবেদন জানাইতেছি।
This must be her application. This is of 98. Which other application? Please read what is the application.
আমার বিনীত নিবেদন এই যে আমি রুনি বেগম স্বামী মৃত জারিস শাসন শাস কর্মরত অবস্থায়।
This is the application of 98. See in the bottom what is the date given.
98 of 2/12/1998.
So this is the application of 98.
No, this is not a mother. This is not a widow. This is for the reserve for the son. Prayed for the son.
The council, you said in 98, your mother made an application for you.
Yes, sir.
So what is the date of that application?
2/12/1998.
So this is not the application made in your favor. Page 39 is not the application.
It is in my favor, my God. It is in my favor.
Correct. It is in your. This is the application.
This is the application.
What are you saying? It is in your favor. What was your name? What is your? Show, read.
Sohrab Hossain.
Please read what it says. Page 39.
আমার কন্যা বিবাহযোগ্য এবং তাহার বিবাহের ব্যাপারে কথাবার্তা চলিতেছে। এক্ষণে আমি আমার কন্যার পরিবর্তে আমার একমাত্র পুত্র মোহাম্মদ শাহাদাত হোসেনকে কনস্টেবল পদে চাকরি দেওয়ার জন্য আবেদন করিতেছি। প্রকাশ থাকে যে আমার পুত্রের বর্তমান বয়স 5 বছর এবং সে যখন চাকরি পাওয়ার পূর্ণ করিবে, বয়স পূর্ণ করিবে, সেই সময় যেন চাকরি পায়।
Read from the first, from the beginning. Read from the beginning.
But prayer for recruitment of my son.
Why are you reading the prayer portion? Read the entire.
Well, I'm going fast. From
the beginning.
Prayer for the recruitment of my son, MD Shahadat Hossain, as an exempted category candidate. মহাশয়, আমার বিনীত নিবেদন এই যে আমি রুনি বেগম স্বামী সাসান সাস আপনার নিকট আমার স্বামী কর্মরত অবস্থায় গত 3/4/98 তারিখে মারা গিয়াছেন। আমি ইতিপূর্বে আমার কন্যা মোসাম্মদ চামেলি খাতুনকে চাকরি দেওয়ার জন্য একটি দরখাস্ত করিয়াছিলাম। আমার কন্যা বিবাহযোগ্যা এবং তাহার বিবাহের ব্যাপারে কথাবার্তা চলিতেছে। এক্ষণে আমি আমার কন্যার পরিবর্তে আমার একমাত্র পুত্র মোহাম্মদ সাদাত হোসেনকে কনস্টেবল পদে চাকরির জন্য মনোনয়ন করিতেছি।
Yes, how your claim could have been considered when you were 2.5 years old for compassionate appointment? Could not have.
My lord, I have been considered, that's why the notification was issued in favor of me for appearing with the physical test.
That creates any right. Consideration creates right.
But the,
Order was not, final order was not issued.
my lord, thereafter, it is very clear, EMP 251 2018, that at the time of consideration of my application, my yes shall be measured. Not the minor at the time of the application, but at the time of consideration. My application was considered in the year 2014, my lord. Let's say at the time of consideration of my application, I was measured. And I got the measure.
So what is the scheme which was applicable in 98? Show us.
Well, at present, it is not with me, my lord.
That is your only case. You are saying this is they are relying on EMP 251 of 2013.
2018, my lord.
2013. They are relying on EMP 251 of 13. So you are raising a grievance that why they are relying on EMP 251 of 13. Therefore, we are asking you what was the scheme applicable in 98. Show us. What does it say? Whatever is the age, it can be given. 2 years, 3 years, 6-month infant can also be given. Show us. What is the scheme?
Well, at that time, so far the scheme is concerned, but at present time it is not available to me. That at the time of consideration of my application, that's because it is my application was considered in the year 2014. And during that time, I have got the.
If it was considered in 2005, what would have happened?
Well, 2000, clearly I have mentioned that I am minor.
Therefore, you would not have got it. Before 2014, you could not have got it. You only attained majority in 2014.
My lord.
So therefore, how it could be considered before 2014? What are you saying?
Well, in case of the
how it can be considered prior to 2014? You were not a major before 2014.
That's why they have considered the matter in the 2014.
Correct.
And after considering my later, my application, they have issued the notification for my.
If that is all your argument, then we have not. Then we will consider that right now. Just because they have called you, therefore you must be given appointment.
No,
therefore we are asking you what was the scheme in 98. Are you want to show us? Then otherwise we'll proceed.
I shall introduce that on next day.
So come with it. That we are trying to give you a chance. You are yes. Come with it. The submission of the learned counsel.
Yeah.
Item number 36.
May it please, my lords. May it please, my lords. My lords, I appear on behalf of the petitioner. I beg to lay forth the affidavit of service.
Yes, at the time of.
When 2013 scheme had already come into operation.
I agree with my lords.
Then
But
what
my
is
lords,
your-
there is another continuation to it.
Yes.
EMP 26 EMP dated 1st 1/3/2016, my lord.
Yes.
It is not a part of my petition because I've simply attached two documents. One, my
That is the
OA
one,
application.
that is the one which provides that it can be considered up to 5 years.
Yes. And
Under
there is no
extraordinary-
age limit.
There is no age limit means?
I beg to draw my lord's attention to the respective
There is,
notification. my
see,
lords.
any age limit, any age criteria has two limits. One is the minimum and one is the maximum. Minimum age limit there has to be. Otherwise, you cannot be granted any appointment. Maximum age limit may not be.
I agree with my lords, but
Therefore,
the
don't say that-
omission, the deletion, in other words, the amendment to the 251 EMP dated 3rd of December 2013 is very categorical, which is why I beg to lay forth
Yeah,
before
we
my
have it.
lords.
We have it. What are you relying upon? Tell us.
My lords, going by the operative part of the impugned order, which may be found in, I have mentioned the part in paragraph 20 of my petition, and it is there in the second last page of my.
No, see, we are not required to go through much pleadings. For the simple reason, there is no dispute that you were 15 years, 4 months and some days.
During the
at-
time of death.
At the time of his demise, unfortunate demise in 2015. Therefore, you say that 2013 will not apply because there is an amendment in 16. Now, which circular is to be considered the time?
Because my first application was on 8th of March 2016. The EMP 26 EMP is dated 1st of March, which is already in operation, 1st of March 2016. So this was in operation when my first
When you made the application.
Yes, my lord.
All right.
So in that case, my
So where
lord,
is, let us see the
there is a
16.
relaxation of this clause which was deleted. The concern which may be found in page number 67 of my writ petition.
No, let us come to the 16 amendment first.
Yes, 16 amendment.
What is the date of that amendment?
Date of that amendment is 1st of March
1316.
1316.
Yes, it says maximum 5 years. Decision must be based on a lot of circumspection or something like that.
There is another important clause added.
Yes.
Exceptional circumstances
Exceptional
up to.
circumstances.
I will show how my case falls within the category of exceptional circumstances.
Yes. We want you to show us.
My lord, if my lords be pleased to come to page number 67 of my petition, that is section 6, subclause 3, subclause C, and subclause C. 6CC. A
Age
dependent member invariably attain the age for requirement within 6 months. So even in the previous, it was 6 months.
Just let me find the page first. Yes.
67.
67.
The first paragraph.
The dependent member.
So EMP 251, this clause is being relied upon. Whereas this clause was completely deleted in the 2016 amendment. So the minimum age limit as to during the time of death.
Yes.
Goes out because that option is deleted, amended. There is no certain
therefore,
amendment is addition plus omission.
So this
here is only omission. There is no addition.
This is then in 2000, after 2016, someone who is 12 years can also be appointed.
No, my lord, that is not. Then there comes 10 CC, my lord, which is again
Therefore,
the
no
exceptional
appointment can be
circumstances.
offered to anyone below 18 years.
I agree with my lord.
Because it is a settled law that a service is a contract.
I agree
And
with my
anybody who is not a major cannot enter into a
I
contract.
agree with my lord.
The law is settled.
But the question is, on my first application dated 68th of March 2016, I was not the person being promoted for compassionate appointment. It was my elder brother. I needed compassionate appointment only because to come over the surviving limitations of my family, the financial limitations of my family.
No, then
My
let's-
brother was brutally murdered in 2018.
All right. So you are,
Only then
you are seeking
my candidature came.
2018.
Yes, my lord.
You said you have applied in 16?
16, the first application. Here, what happened, my lord? My father died in 2015, October 2015. My mother, we all nominated, we had to come over the hardship. We nominated our elder brother.
Okay.
My brother was murdered, and it's a very famous case of 2018 Panchayat elections. The Nayan Mondal murder case. So Nayan Mondal was the first candidate. When in 2018, my brother was murdered,
2015.
2018 Panchayat elections, my brother was mad. My father died in October 2015. My brother, the first candidate,
And his application was within time.
Within time, age limit, no obligations as such, man.
All right. Then
2018, my brother died, and I'll show my lords how there was security issues, there were hardship.
it's hardly
multiple
relevant.
case
That
laws.
is hardly relevant for compassionate. Don't digress.
Hardship is one of the major issues, my lord, for
No.
which compassionate appointment
That's
is sought
not
for.
the issue right now. The issue is he is not there anymore.
He's not there anymore, which
So
is
therefore,
why.
yes.
Which is why. The
Yes.
second application, first on in the year 2018, and the second application 2019. I was called for an interview, physical test, and
When did you make your first application?
8th of March 2016.
How are you linking it to his demise? He has died after your application.
But that application was for my brother, not for me. My first application was 2018, after my brother's date.
So on the date you made an application, there were two applicants for compassionate appointment.
Yeah, the first one expired. The second one I was placed for.
May I try?
How do you say he expired? You say he expired in 18. You are making an application in 16.
My lord, be pleased to come to page number 51 of my petition.
But he said 2018.
My lord, be pleased to come to page number 51 of my petition.
Give us the date. We'll come to the pages later. What is the date of your brother's demise and when did you apply? These are the two relevant dates. You say 18, he died, 16, I applied. You say because he died, I applied. How can we
My brother
reconcile
dies.
this?
My brother dies on around June 11th June 2018.
Then how your application
And my application putting forth my candidature was on 14th of June.
Of?
14th of June 2018.
18?
Yes.
Till now you were telling us 16. That is the
2016,
confusion.
My brother's first application in favor
His
of my brother.
application, yes.
That is also there in my petition.
All right. So you applied after his death?
After his death.
And till that time they had not processed his application?
No, nothing was done as such. My brother was not called for an interview or written examination. I was called for.
Yes, then?
I was called for a written. I clear that. I clear everything. But all it comes down to is that 251, which was not even in operation, even when my brother's application was made.
No, whether 251 will apply, we'll see. We'll come back.
So then, my lord, it was 26 EMP was in application then.
Opposition and all filed before the tribunal. So we'll consider tomorrow.
Much obliged.
Not today.